draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Today is June 9th. Welcome to Lawrence County Municipal Court. I'm Judge Caffer. We have a very big docket today, so take some patience to get through it, but we will. We first do reviews for people who have been ordered to do things. This is a review of the progress being made on those cases. Bailiff's going to call the names of people in a group. When your name's called, come up. If you're out smoking or in the bathroom, you get called and missed it, you're going to go to the end of the docket. Also, when you people for pretrials, when your case is set for pretrial, be in the courtroom. We're not waiting 2 minutes for people to come from outside because they like to hang out there. You miss when your case is called, you're going to go to the end of the docket, which could be 1 o'clock this afternoon before you get called. Call the reviews, please.
James Adams, Lexus Anderson, Leroy Campbell, Haley Early, Christopher Hale, Heather Humphrey, Jenna Justice, Clarence Mahan.
We need the reviews in the courtroom now, so if you got a pretrial, you don't need to be in here yet. It's going to be a while before we get to you. James Adams, 23-765. James Adams. James Adams hasn't appeared. He has no DI. He did not. He hasn't done the drug intervention program, so there'll be a warrant issue for failure. Lexus Anderson.
Yes, sir.
24-1605. You've got, you have done some community service since the last time.
Yes, sir.
You still have some days to do, and you still have fines to pay.
Yes, sir.
What about OVP? Are you still going there? Or?
Yes, sir.
So,
I had a letter, but I don't see Bree. She's usually who's.
I haven't checked my emails, Your Honor. I don't know if Bree's going to be here today or not. She's not going to be here today. Okay.
Okay.
If you want me to, Your Honor, I can reach out to her and to Bree and see.
She did send me a text, not about her, today about William Kaplinger, who left treatment. So obviously she's aware of what's going on today.
Yeah. I believe her child may be sick, Your Honor, is why she's not here.
Okay, so I'm going to text her about you, so just have a seat, and usually she responds pretty quickly.
Yes, sir.
And I'll recall you. Leroy Campbell is here. 10-6-27, 12-22, 59, 12, 30, 25, and he's at RRS. And still compliant.
Yes, sir.
And working full-time.
Yes, sir.
So, very good. Can you pay anything on your fines today?
Yes, sir. $50.
Have you done that yet, or?
No, I have it on me right now.
Okay. All right, good job. And are Mondays best for you?
It doesn't matter, sir. Whenever. My job's pretty lenient with me about this.
You just give them a date and they let you?
Yeah, they're pretty cool with it.
Okay, good. Glad you're doing well.
Thank you.
Okay, I'll set it for July 14th as your next hearing.
Thank you, sir.
See the clerk.
Yes, sir.
You're one of our success stories, Mr. Campbell. I'm proud of how well you've done. Thank you. Haley Early. 2480. Are you Miss Early?
Good.
Are you still going to OVP?
Yes.
Okay. Do you have a report from them?
No.
Do you think you're compliant?
Yes.
Okay. Well, text Ms. DeMint about you too. Are you making a payment on your funds today?
I paid Friday. I think I owe $5.
That's correct. You still have community service to do. How are we going to get that done?
I'm gonna try to be able to come on a Saturday. It's just hard to find somebody to watch the kids on Saturdays. I
How
work
about
Monday through
grandmas?
Friday.
You used to watch them, so
Yeah, it's just hard.
I understand. Okay, well, go pay your $5 and come back. I've texted Ms. DeMint to get a report on you too, so I'll recall your case once you get a report back.
We do have a report now on what's the same thing.
Okay, Alexis Anderson, you can come back up. I do have a report for you. Okay, it's actually letter of completion, so they say you are completed with your counseling and that you were compliant. So
Yes, sir.
they suggest if you want to continue,
I am.
you can,
I am.
but I'm not going to require it. So.
I'm going to. Thank you.
Okay, so you still have quite a bit to pay on your funds, and you still have
Yes.
some community service to do.
Yes, sir.
You have done some since your last hearing. Are you working
Yes, sir.
Mondays or Fridays for your reviews? Does it matter?
Either or.
Okay. I'll set you for July the 18th, that's a Friday. 9 o'clock, July the 18th is your next hearing.
Yes, sir. Thank you.
Good job on your counseling.
Thank you.
Christopher Hale, 204087, Christopher Hale. He's at RRS, or has been.
He has been. He's an outpatient client, but I have no reason why he isn't here right now. Mr. Hill has been compliant.
Okay. And he did quite a bit of community service since his last hearing. So what I'll do, I'll give him 7 days to appear before I issue a warrant. So if you can let him know he missed his hearing, please. And he still has $550 that he owes on his fines and court costs and 24 hours of community service. So if he gets in here before next Monday, which is the 16th, he won't have a warrant.
Thank you, Your Honor.
Heather Humphrey, 24/1981.
Hi, Your Honor.
Good morning. Okay, you did a day of community service. You still have 4 days left,
Yes.
and you still have fines and costs to pay quite a bit. Are you
Yes.
paying anything on your fines and costs?
I only have $7 today, and due to my restitution, I put it on a card, and it got stuck on the card, so, because I put the wrong email in, so I'm waiting on them to send me a check to my grandma's house. Temporarily, I'm still homeless, but I've reached out to branches, and I've been with Prestera for years, and they're trying to help me find housing. So,
Okay, and you have to do, I don't see that you've done the driver intervention part. You have to do that too. You realize that?
I have a question. So I got Medicaid now, where I'm homeless. It's through West Virginia. Does that help cover any costs?
Not that I know of. Is there anyone here from the driver intervention program today? I don't think there is. Okay, so one thing I could do here, Juanita's here from Thrive, and do you need help with your driver's license too? Do you have a driver's license now?
I have the work permit because, well, at first I was with Beltone for 5 years, but due to my mental health and the hours, I was working 95 hours basically, and living out of my car is just not suitable to.
Are you West Virginia or Ohio?
Well, I was living in Ohio when the domestic violence situation happened, but I stay at parks and stuff in West Virginia.
Do you have a medical card?
Mhm.
From which state?
West Virginia, because that's where I worked the longest.
Well, then Thrive can't help you. It has to be Ohio Medicaid.
Okay.
I'm just going to refer you for a peer recovery
Okay.
coach that maybe can help you with some of your issues, but
Okay.
they can only accept Ohio. They can't accept West Virginia.
Yeah, they wouldn't let me file because I did unemployment as well, which got denied. and then I appealed that. So I lost my job at Beltran in January the 27th, I believe.
Where are you living now?
In my car,
In your car, okay.
yes. But I stay at friends' houses and stuff, you know, in between.
But at the time this incident occurred, you had an address in Chesapeake?
Yeah, that was the abuse.
Where are you from? Where did you grow up? What's your roots?
Crown City, Miller, but it's not a good place for me.
Okay. Well, I'll give you some more time to get this stuff situated.
I appreciate it. I
Do
still.
you have any children?
No.
Okay. All right, well, keep coming to your hearings, do what you can. You can do community service. You have 4 more days to do, and actually you can work off, I'll let you work off your fines and costs by doing extra community service.
Okay, yeah. I work night shift now, which is also, like, because my schedule used to be 8 to 6:30. Now it's like 7, 8 to like 2 in the morning, 3 in the morning.
Where are you working?
It's called Go Green, but it's for Sitco Water Company. It's a cleaning business.
Okay.
And he also has me do like side jobs and stuff. It's just, it doesn't even cover the bills. I may possibly lose my car. I'm not sure yet.
Okay. Well, I'm sorry about that. I mean, you got this, it's an OVI conviction,
Yeah.
so it's got to be dealt with.
Yeah, exactly. I'm going
I'll
to try
give
my
you some more
best.
time. We'll work with you as much as we can.
I appreciate it.
So I'll set your next hearing for, write this down, July the 18th at 9 o'clock.
9 a.m.
Yes.
Thank you,
ma'am.
Your Honor.
You're welcome.
I will do my best to get in here this week to get some community service. Thank you.
You're welcome. All right, Jenna Hawthorne, Justice, 242544. He's at RRS. Okay. There's been, and it sounds like you've been going to your sessions, but you haven't had until last week or so, you didn't have a clean screen, as I understand it. So, the one thing I want to remind you of is that I gave you a 10-day jail sentence, which I said I would withhold if you successfully completed it. So, you still have that hanging over your head, you understand that? So you gotta get successful completion of your counseling before you're out with woods on going to jail. Okay, you've already paid off your fines and costs, so we'll keep working on your treatment, and let's get a better report next time. Okay, I'm going to set your next hearing for July the 14th. That's a Monday. July the 14th at 9 o'clock. Clarence Mahan.
Thank you, Your Honor.
You are 24674, 675, 21187. And you just have to pay off your fines. You have a payment today.
I've got 20, yes.
Okay. See the clerk to make your payment. I'm going to set you for July the 11th, which is a Friday. July 11th, 9 o'clock.
Thank you.
Michael Martin, Ray Meredith, Brandon Miller, Harold Moore, Shane Ortiz, Logan Wright, LaDonna Walter, and Aiden Young.
Okay, I'm Haley Early. Is she still in the courtroom? Okay. So, Bottom line, I've got a report back from Brand that you have come some, you missed some appointments, and she recommends you being screened here today. So I'm going to order you to go do your screen. Okay, Michael Martin, 22-163, 19-4006, is it RRS?
Last week, he had a stroke. He went into the hospital, and now he never came back to us.
Okay.
So he's discharged.
They did call me, Your Honor, and let me know they wanted to send him.
And so it looks, according to the report, you tried to contact him, and someone other than him answered the phone and said he wouldn't be coming back.
Correct.
Okay, so I'm going to issue a warrant for him. He didn't appear for his hearing and he left treatment. So a bench warrant will be issued. Thank you for the report.
Yes, sir.
Ray Meredith, 2038. Okay, you've got still community service to do and fine with that.
Yes, sir.
We got to get the community service done. Give me a date when you're going to be out.
This week, I would have been out last month, but my fiance found out her mother had stage 4 cancer, and she has been my only ride.
Where do you live?
Out getaway.
Okay. Well, you got to get here.
Yes, sir.
Give me a date when you're going to be here this week.
I'll be here in the morning.
Tomorrow?
Yes,
Okay.
sir.
Got you down for that. Set your next hearing. July the 11th at 9 o'clock. Once you get this finished, you can quit coming to these hearings. You've got 3 days community service, $250 in fines. Are you making any payment on your fines there?
I will be able to Friday.
Okay.
And you said, I'm
July
sorry,
the 11th is your next hearing, 9 o'clock.
thank you, Your Honor.
You got Brandon Miller, 23-184. Brandon Miller.
Hello.
All right, Brandon Miller's on teleconference. It's on an OVI conviction. Community service is done. Dip school is done. Still have some to pay on your fines. You did make, there is a payment that came in today for $50.
Okay, great, $50.
Yes, we've got that on record. Okay. July 14th is your next hearing. Get it paid. You don't have to come in. I'm showing it's $370 now. July 14th, 9 o'clock is your next hearing.
Is it possible to do a Friday instead of Monday?
Yes. July the 11th.
Okay, sounds good, thank you.
July 11th, 9 o'clock. It's Mr. Miller's next hearing.
All right.
Harold Moore, 23-550, 23-1259. Harold Moore. Has not finished and hasn't appeared, so it'll be a bench warrant for failure to appear. Shane Ortiz, 25-267. Shane Ortiz has done all his community service. He has been going to Pathways. I did get a report from them last month. He's not here today, and I don't have any report from Pathways for this month, so it is your warrant for failure to appear. Logan Rife, 24-512. Still owes fines and court costs, hasn't appeared, so it'll be a bench warrant for failure to appear. Rodonna Walker, 24-609. All all your community service is done, you've done extra towards your fines and court costs, and quite a bit since the last hearing.
I think I just have 5 days left that I'm going to do community service for.
Okay.
Your Honor, she came spoke to me before court and advised her that I think she's got $250 left on her fines and court costs, and another 30 hours of community service to take care of that.
Okay. All right, I'll set your next hearing. This is a newer case, so I'll give you more time before your next hearing. I'll make it July 21st,
Is that a Monday or a Friday?
Monday.
Can you do Friday, please?
Yes, the 25th, July 25th, 9 o'clock.
Thank you.
You're welcome. 8 Young, 1446. You completed the driver intervention program recently. You paid your fines, you just have to do your community service.
Your Honor, if I may, he's turned in some community service this morning. I haven't had a chance to look over it.
Okay. All right, I'll give you another review hearing day. Check in with Mr. Major to make sure. You think you've got the 30 hours done, or?
I'm at 12.
Okay.
I'm finishing. I've been doing that at the dog shelter.
Okay. I'll set your next hearing for July 25th. Get it done before then, you'll have to come back in.
Yes, Your Honor.
Okay, the next hearings are what are called the arraignments, which is the new cases, or if you had an old case where you got a warrant issue because you missed a hearing or didn't do something, then you'll get called with the arraignments. When your name's called, again, come up to the table to your right, like the last people did, and I'll go over the charges with you. I don't decide what charges are filed, that's what the prosecutor does. In conjunction with the police agencies, they decide what charges to file. So I don't know anything about the charges. They may not be true, could be false, but I have to tell you about them so you understand what's alleged against you. You don't have to agree with it, but you need to understand it. You have a right to remain silent. You don't have to say anything. If you choose to make statements, everything you're saying and everything I'm saying is all on the record. Everything is being recorded. So if you admit something about your case, the prosecutor can use that against you later. So this is not the trial. A lot of times people want to get up and start telling me what happened. I'm not going to say, oh, you're right, the case should be dismissed today. That's not going to happen. So it doesn't do any good to start telling me what you think happened. You have a right to have an attorney. Save it and talk to an attorney about it if you want to go over what happened. You have a right to have one appointed if you can't afford one. You have a right to bail, to make the state of Ohio prove the charges against you beyond a reasonable doubt. All those things I just told you, those are the rights that defendants have. If you decide to enter guilty or no contest, you're waiving those rights. You should not waive your rights if you don't understand what's happening. If you're confused, if you want to talk to a lawyer, if you want a trial, any of those reasons I just said, enter a not guilty plea. Not guilty is the safest plea to enter. It preserves all the rights you have. A lot of times people say, I just want to get it over with. That's not a good reason to enter a guilty plea. Call the first case.
State of Ohio versus Melissa Clovers.
Ma'am, the first time your appearance, missed the hearing or have a warrant, you missed the room now.
Ma'am, are you Melissa Clutters?
I am.
Please all sit down together.
Have you received a copy
Let's
of
get
the
together,
charge?
we got a big crowd today.
All right, Ms. Clutters, the charge against you is aggravated menacing. The state's alleging that on April 23rd of this year in Perry Township, you knowingly caused Brittany Workman to believe you would cause serious physical harm to either her person or to her property. Aggravated menacing is a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail and a $1,000 fine. Do you understand the charge?
Uh-huh.
Do you understand the rights you have?
Yes, sir.
How do you plead to this charge?
I'd like to get an appointed attorney if I could, please.
Okay, so I'll enter a not guilty plea for you.
Okay.
Are you working?
I work for my mom. She has some Airbnbs.
Okay.
But besides
Well,
that-
I have to determine your gross annual income.
Oh, no.
So do you know what, you file an income tax return?
No, it's nothing like that. So no, I don't have a job.
So is it below 20,000 a year, do you think?
Yes, sir.
Okay. I'll appoint Mr. Holt to represent you.
Okay?
He's here, so we'll get him in the courtroom. Mr. Hall, could you get Mr. Holt, please? And I'm going to let you sign what's called a signature bond. Good morning, Mr. Holt. I'm appointing you. This is Melissa Clutter. She has an aggravated missing charge. So I'm going to let her sign a signature bond of $1,000.
Yes.
Not guilty plea is entered. And I'll set her. She probably does. Okay, let's put on the bond entry, and she'll need a copy of it. You have a separate? Okay. She'll have to report to the jail, Mr. Holt, to get fingerprinted. Yeah, she'll have to go to the sheriff's office to get fingerprinted. Take a copy of the bond, Mr. Paul, if you can make a copy of that for her, give it to her, and then the original for the file. And then, Mr. Holt, what's your availability for a pre-trial?
Your Honor, I wouldn't be available till July 7th.
Okay, that's fine. Okay, Mr. Hawk, if you can take that, make a copy of it, give her a copy with the original. $1,000, July 7th. Okay, July 7th will be the next hearing.
Thank you, Your Honor.
You're welcome.
Thank you very much.
You're welcome.
State of Ohio recalls Haley Early, case number CRB 2480.
All right, and you're testing positive for alcohol, and marijuana. So I'm sure that's not what you're supposed to be doing. Now, the last one, the ones we had in April was clear, so let's clean that up. You gotta get your community service done. I'll set your next hearing. Does it matter if it's Mondays or Fridays?
No.
July the 11th,
Thank you.
9 o'clock, July 11th.
State of Ohio versus Daniel S. Barker, case number CRB 25262. Daniel S. Barker.
Daniel S. Barker. There's no proof. Well, this is insufficient proof of service. It was served by a summons, but I can't tell, who signed this, it's just a scribble. Can't tell if it was actually signed by Daniel Barker or not.
Is there a printout your own, or you can do a printout from the post office site?
I don't have
I
that.
will make that determination.
I'll have the clerk check. If there is proof of service, then I'll issue a warrant. If not, it'll be passed for service. So I'll put a note on it.
State of Ohio versus Emily Nagy, case number TRC 25-1308, A and B.
And she went out in the lobby. Melissa Clutters. Emily Nagy, is it Nagy or Nagy?
Nagy.
Nagy. All right, Ms. Nagy, you've got a charge alleging that on June the 6th, 2025, at 4:23 p.m. in Fayette Township, you were operating a vehicle while being under the influence of alcohol, drugs, or some combination of those things.
Yes, sir.
And so this would be your first conviction if you got convicted.
Yes, sir.
So on a first offense, the maximum you face is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most that can happen if you're found guilty.
Yes,
There is a minimum, so the least that can happen is 3 days in a treatment program, $375 fine, and a 6-month license suspension.
Yes,
Do you
sir.
understand the possible penalties?
Yes, sir.
And that's the only charge that I see you have.
Yes, sir.
No, you have one other charge. Illegal window tint. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand those two charges?
Yes, sir.
If she left, give it to Mr. Holt. How would you like to plead to these charges?
I'm waiting on a call back from my lawyer.
So we enter a not guilty plea?
Yes, sir.
Do you wish to be considered for a court-appointed lawyer?
No, sir.
Okay, you're going to hire a lawyer?
Yes.
Okay, I'm going to let you sign a signature bond since you've appeared on your own today. You can sign a $1,000 signature bond. How much time do you need to make arrangements to get a lawyer?
They're supposed to give me a call back sometime today, sir.
Okay. So what you're signing is a piece of paper that promises you'll be in court as ordered. If you don't appear, then you'll be ordered to pay the $1,000. So you're guaranteeing your own appearance. That's why it's called OR, own recognizance.
Your Honor, was Ms. Nagy fingerprinted or she need to be fingerprinted?
Well, probably not, because I think she was cited in the court. So I have to check the box for getting fingerprinted. It's a thing the Attorney General's requiring us to do now. So if you were taken to the jail, you would have been fingerprinted. But if you weren't taken to jail, you don't get fingerprinted. You have to go to the sheriff's office and be fingerprinted. So we need to make a copy of that, give her a copy of the bond, and take it to the sheriff's office. Let's set it for, does it matter if it's a Monday or Friday? It's going to be a Monday or Friday.
Preferably Monday, sir, please.
Okay, June 23rd. So 2 weeks from today will be your next hearing. It'll be a pretrial at 10 o'clock.
What was that date?
June 23rd. She will hire an attorney. Not guilty is pled here. Do you have any questions, ma'am?
No, sir.
You are under an automatic license suspension. You understand that?
Yes, sir.
Okay. Next hearing, June 23rd at 10 o'clock.
Thank you.
She hadn't signed yet?
She decided on
Okay.
her position to do it.
Yes. Don't leave, Ms. Nagy, until you get a copy of the paperwork to take to the jail.
State of Ohio versus Carlos Martinez, case number TRC 25-1246, A and B. This is what we need.
Have you got the interpreter on the line?
Yes.
Okay.
Your Honor, would you like the phone first?
We can do it. I can do it. I may need you to take it back and forth.
Again.
All right, good morning, Miguel. Are you there? Yes, okay. All right, so we have an interpreter supplied through the Ohio Supreme Court by telephone, and you're going to translate. This is an arraignment hearing today, and Mr. Martinez has an attorney, Mark McCown. So, do you wish us to read the charges, Mr. McCown?
No, Your Honor. We'd waive
Okay,
reading.
that.
Yes, Your Honor.
Enter a not guilty plea.
Yes, Your Honor.
Do you have a preference for a pretrial date?
June 27th, if that's okay, Your Honor. That's a Friday. We filed discovery today.
All right. I'll set the pretrial for June 27th at 10 o'clock. Mr. Martinez can sign a signature bond since he's appeared today and has counsel. I'm assuming he did not post a bond before. I don't see it.
I presume that's correct, Your Honor.
Do I need to have the translator tell him about the OR bond?
That would probably be better for the record.
All right. Miguel, if you could tell Mr. Martinez, I'm having him sign his own recognizance bond for $1,000.
Bien, señor Martínez, lo que debo estar solicitando es que firme su fianza sobre mi palabra por $1,000.
Can you repeat that, please?
Of course, no. Lo que le voy a estar solicitando, señor Martínez, es que pueda firmar su fianza bajo su palabra por la cantidad de $1,000.
Okay.
Please tell him if he appears in court, he will not have to post any money. If he fails to appear, there would be a warrant, and then he would have to pay the money.
En caso de que usted se presente en la corte, no va a tener que pagar dinero. En caso de que usted no se presente en la corte, una orden de arresto será emitida en su contra y va a tener que pagar esa cantidad de dinero.
Please ask him if he has any questions.
No, Your Honor.
Do I need to, you can explain the date to him, Mr.
Yes, Your Honor. I'll do that right now.
All right, Miguel, thank you for translating. I think that's all we need.
That is correct, Your Honor.
Please enter next hearing, June 27th, 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Benny Inyard, case number TRC 25-1321, A, B, and C.
Sir, are you Benny Inyard?
Yes, sir.
Mr. Inyard, it's alleged that on June 7, 2025, at 6:43 p.m. in Fayette Township, you were driving a vehicle while being under the influence of drugs or alcohol, or a combination of those things, and that you refused to take tests. It's alleged this would be your first conviction if you got convicted. So on a first offense, the maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. The least you can receive if you're convicted is 3 days in a treatment program, $375 fine, and a 6-month license suspension. Do you understand that?
Yes, sir.
You're also charged with driving without a driver's license. That is what's called an unclassified misdemeanor. no jail time, but it does carry a maximum penalty of 500 hours of community service and a $1,000 fine if you're found guilty. The last charge is driving an unsafe vehicle. That's a minor misdemeanor. Maximum penalty is a $150 fine. So you have 3 charges. You understand those 3 charges?
Yes, sir.
You understand the rights defendants have that you have as a defendant?
Yes, sir.
Any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
Guilty.
Guilty means you're admitting the charge is true. By doing that, you waive the right to have a trial, to have a lawyer, and to make the state of Ohio prove the charge against you. Do you understand that?
Yes, sir.
Okay. I'm going to accept your guilty plea. I'm going to read the officer wrote a report to the court about what they allege happened. I'm going to read that into evidence now. And then after you hear what's said, if you want to make an explanation or statement yourself, you can. You're not required to. Okay, so the officer wrote to the court on June 7th. I was stationary patrol near County Road 410 and County Road 1. A male on a red ATV that was not registered or having plates passed me. I activated my overhead lights and did a traffic stop. The driver was identified as Benny Enyart. When I made contact with Mr. Enyart, he told me he was coming from work and was going to the Speedway to get gas for his ATV. He had a strong odor of alcohol coming from his breath, and his eyes were watery and bloodshot. Asked him how much he had to drink, he told me nothing. Asked him to step off his ATV, go back to the patrol car. Asked him again how much he had to drink, he told me he had drank 1 Voodoo Ranger. Once Mr. Enyart was in front of my patrol car, I asked him if he was willing to go through field sobriety test to make sure he was okay to drive, and he said yes. Asked him some pre-medical check questions, asked if he had any head, back, neck, or knee problems, and he told me no. Told me he could walk 9 steps, a straight line if he was asked to. I asked him if he wore any contacts or glasses or was on any medications, and he said no. I had him stand with his feet parallel together, interlace his fingers and place them under his chin. I did a pre-medical check, and there was a lack of smooth pursuit, and there was also sustained stagnance at maximum deviation. So there were 6 clues total on what's called horizontal gaze and stagnance test, which is the eye test for the presence of alcohol. While Mr. Enyart was doing these tests, he was constantly swaying side to side and front to back. Walk and turn test, asked him to get into the instruction position while I demonstrated the test. Asked him if he could imagine a straight line. Yes. I observed that he was stepping off the line while walking, turned incorrectly, lost his balance while turning, did not touch heel to toe. Gave him the one-leg stand test and demonstrated how to do this. He kept putting his foot down on the one-leg stand. He was placed under arrest for suspected OBI, read his Miranda rights, searched the bag that was stored in the passenger seat. He was placed in the patrol car. He was offered a urine and breath test, which he refused to take. Asked him actually how much he had to drink. He told me he had 4 Loco, I don't know what that is, Loco, L-O-K-O is what he said. Also said he smoked some marijuana 20 minutes before he was stopped. There was a small bag of marijuana in his pocket. He was towed by C&M towing the vehicle, but you were released on the scene. You were given a portable breath test and tested 19 on portable breath test. Okay. Do you have any statement or explanation you want to make?
No, sir. I know I was in the wrong. I wasn't at work. I was at work, but I wasn't working. I was just there at the moment getting something from work, and I just didn't have access to my vehicle at the moment. So that's when I decided to take the four-wheeler. And like I understand, it was in my wrong.
Okay. Well, you were driving on the road, right? Or?
Yeah. I have to go that way to get to work. And like I said, I just didn't have a vehicle or anybody to take me at the time.
When's the last time you had a driver's license, or have you ever had one?
I took a test years and years ago, but other than that, no, I've never really went back to go try again. Because most of the time my old lady
Are
drives
you
me
still
around.
living in South Point?
Yes,
And, okay. Well, I can't give you any driving trouble just because you don't have a license, so you will get a suspension for 6 months, which will just mean since you don't have a license, you won't be able to get one for at least 6 months because
Okay.
of the suspension, and you'll have to reinstate before you can get a license.
yes, sir.
There's also no, excuse me, no proof of insurance.
Right. Yeah, so he's going to get two, you're going to get in effect 2 suspensions. You're going to get one from me for the ODI, which is mandatory under the statute. Then the way it, and I didn't design the system, I probably wouldn't make it this way, but this is the way it works in Ohio. You don't have to show proof. Some states you got to show proof you got insurance when you get your license renewed. Here you don't have to. You sign a piece of paper at the bottom that says, yes, I have financial responsibility. They don't want to say the word insurance in court. We don't talk about insurance. But you sign something that says you have that, and then if you get stopped, you got to show the officer, you know, the little card they give you, you're supposed to show them that card that you had proof of insurance. If you don't, once the DMV sees that you got a ticket and no proof of insurance, they're going to give you another suspension for not having insurance. So that's going to just make it harder for you to get your license eventually. You'll have to square that away with the DMV.
Yes, sir.
You probably have to come up with an SR-22. You've never heard that?
No,
That's where
sir.
you actually then have to file proof of insurance with the DMV, showing that you do have proof of insurance when you get your license.
Yes, sir.
Okay, anything else you want to tell me about this before I send you?
No, sir. I just, like I said, I was in the wrong at the time. I just, only means of transportation, and I got on it and left, so it was my fault.
Your portable breath test, you didn't take the breathalyzer, but the portable breath tests are pretty accurate from what I've seen in my career here. They come out pretty close to what the breathalyzer, and it was a pretty high test. So,
Sorry, Your Honor.
I'll give you a $500 fine, order you to pay court costs, 20 days in jail, and I'll suspend it on the condition that you do 5 days of community service. You have to go to the driver intervention program,
Yes, sir.
and you have to pay your fine and court costs, and do 5 days community service, if I didn't already say that. So we have a community service program at the court.
Yes, sir.
Where you can do community service every day this Sunday at 7:30 here at the court. There's community service program. You're going to be on probation, level 4 for 2 years, or until you get everything done. Once you get everything done, your probation will terminate. You're going to meet with Mr. Major, who was in here a little while ago. He's the probation officer, and he'll be your contact person with the court.
Yes, sir.
Your review hearing will be December the 8th of this year. You got a review hearing then, you have to show up. If you don't show up and you got stuff left to do, you'll get a warrant.
Yes, sir.
So I don't want you to go to jail.
I don't need it. I got 2 boys to raise, so.
It's not a nice place. I mean, people act like they're not afraid of going to jail, but I've never spent the night there. I've visited it several times. I don't want anything to do with it. So if you do the stuff you're ordered to, you'll never have to go to jail.
Yes, sir.
If you don't do it, what choice do I have? We did away with the stocks a long time ago. Do you know what the stocks are, where they put people's heads in this little thing?
Yeah.
And they had to stand out in front of the courthouse. So it's pretty cheap punishment, but we can't do that. They said that's cruel and unusual. A lot cheaper than jail, because you go to jail, we gotta feed you and have somebody babysit you for every time you're there. So it costs some money. But that's what's gotta happen if you don't do it. So just take care, don't blow it off, do it,
Yes, sir.
and you can avoid jail. Okay, on your no operator's license, I'm gonna give you a $100 fine and 3 more days of community service. So 18 hours of community service. On the unsafe vehicle, $20 fine.
sir.
So, go meet with Mr. Major, his office to the left, when you exit the courtroom, the west side of the building, downriver, left.
Yep.
That's where his office is. Go check in with him. He'll give you some paperwork. This is not just for you, but for everybody. We got a bunch of people listening. Because a lot of times people say, well, I lost my paperwork and I didn't know what I was supposed to do, so I didn't do anything. That's not a good reason. And here's the other thing. We still have telephones here at the court. People that work here still answer the phones, and they love to talk to people and remind them what they're supposed to do. If you call in and say, I forgot what I'm supposed to do, they will tell you. And I'm assuming you've got a smartphone.
Yeah.
Everybody's got a smartphone or a laptop.
Yes, sir.
There is a website for Lawrence County Municipal Court. Go there, put your name in, you can pull your case up. It tells you exactly what you got to do and when you got to do it. There's no excuse for not doing what you're supposed to. So I lost my paperwork, so I didn't do anything. That's a good ticket for jail.
Yep.
That's a good reason to go to jail, because that's not really an excuse. That's being lazy and dumb.
All right.
Okay, December the 8th is your review. It'll be on the piece of paper that Mr. Major's going to give you.
Yes, sir.
And it's on the website. There's a lot of places you can find it.
All right.
So don't blow it off.
I won't. Thank you, Your Honor.
You're welcome. Go see Mr. Major.
State of Ohio versus Tony Walters, case number CRA 23466, CRB 23467, A and B.
All right, Tony Walters is here today. He had a review hearing on May 27th. Like you weren't here then. Is that right?
Yeah.
Do you have a good reason for not being here?
When was that?
May 27th, that was your review hearing day.
I was here and Major rescheduled me. He didn't pull my file or something.
Okay, I don't see, that may be right. It doesn't say benchmark beside it.
Docket shows on May the 27th, there was separate reviewing on June the 5th.
Okay. June the 5th maybe was when, Friday was when you were supposed to be here.
Yeah, I forgot all about that. That's why I'm here today.
Okay, you still have some fine to pay. Do you have anything you're paying on it or working on it, or what are you gonna do?
No, I ain't got nothing today on it.
You gonna work it off, or what are you gonna do?
Yeah, I can't work it off.
Okay, get out here and do some community service. No warrant then, if there was warrant issued. I'll set your next hearing about a month out. July the 18th, 9 o'clock. July 18th, 9 o'clock is your next hearing. Get work off or pay or however you get your fine done.
Okay.
State of Ohio versus Andrew R. Curry, case number CRB 22351, CRA 23464, A, B, and C, CRB 23463, CRB 23291, CRB 2361. Andrew Curry.
Okay, Mr. Curry is here. And your hearing was
The 6th.
also last Friday. Now, one thing I know, did the cleanup ever get done, Mr. Hill? Do you know?
I'm still working on it. The guy across the road let me use his dumpster, and you said last time we spoke that a new code enforcement officer was going to come by and check everything at the residence. But the guy next door, he lets us, we pay him like a little bit of money to, I don't have a lawyer on this. And I have a lawyer like Luke Skyers on my lawyer. I don't care, but I don't care if he's my lawyer, but I thought that was who my lawyer was.
I was his lawyer before, Your Honor, but we completed the cases and he was on the review docket.
Yeah, that's right.
You know, I'm still, like I said before, but when I was out, I'm still cleaning up the property still. I got a lot of yard sale stuff, a lot of back breaking stuff, gotta clean up, I mean, I got a lot of stuff to get rid of, a lot. I only can put so much in this guy's dumpster. I give him $20 a month. He said, don't overfill it, 'cause I gotta put my own stuff in there. But I'm working on it.
All right, when did I set her? Was it the 14th?
18.
18th?
Yeah.
Okay, we'll set you the same time.
Thank you, sir.
So, Mr. Hill, you can try to get a report from Solid Waste District for that hearing. July the 18th, your next hearing. No warrant to be issued on missing last Friday.
Thank you, sir.
Right.
State of Ohio versus Katie Hinton, case number TRD 25-1302.
Ma'am, are you Katie Hinton?
Yes, sir.
Ms. Hinton, you're charged with driving under suspension. It's alleged this happened on June 7th at 12:37 a.m. in Union Township, that you were operating a motor vehicle while you were under a driver's license suspension. This is a first-degree misdemeanor. Maximum penalty is 6 months in jail and $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you plead to this charge?
Guilty, sir.
Guilty means you're admitting it's true. You waive your rights to trial a lawyer by entering a guilty plea. Do you understand that?
Yes, sir.
Okay, I'll accept your plea. I'm going to read what the officer says. I've got the printout. Okay, it's Trooper Sullivan. It says State Route 7. Warning for underglow changing colors. I don't know what that really means. Fictitious tags. Driver was under suspension. So the only thing he charged you with was driving under suspension. It looks like there's a child support suspension, and there's a suspension from Chesapeake Mayor's Court, and one from Cabell County Magistrate's Court. So you got 3 suspensions open.
Well, sir, real quick, that child support should be killed real quick. I just went to court last week for that, and all that's been killed. Just ain't been through the system yet.
Well, it's not in here yet. So you still got the others. You got an outstanding ticket from Chesapeake Mayor's Court that hasn't been, because it's from July 1st, 2020 to indefinite. And then you got one from Cabell County Magistrate's Court from January 14th of 2020 to indefinite. So sounds like you've got some offenses that you never completed, and then they've got your license suspended because of it, those 2. And then the child support thing, you said you cleared out, but it's not showing on your printout yet. So here's what do you want to get your license back?
I would love to. I just don't know how to do that.
Well, you say you took care of the child support on that.
Yes, sir.
You're going to have to take care of Chesapeake Mayor's Court. You can walk, you can go down there, there's Village Hall, and find out what they want, and I'm sure it's going to be money. It's going to be money to pay probably whatever fines and court costs they say they have. And then you got Cabell County Magistrate's Court. Same thing there. You need to check with them. You know, that's in the basement of the courthouse in Huntington. That's where the Cabell County Magistrate's Court is. So you either call them or go in there and find out what they want. And then that's not the only thing you got to do. And you're an Ohio resident. No, you are an Ohio resident, right?
Yes, sir.
So you're going to have to call the Ohio BMV, or you live in Ironton.
No, right here in Chesapeake.
Okay. Well, you got your choice. There's 2 local BMV officers, one in Proctorville and one in Ironton. You're supposed to be able to walk in there now. They didn't used to do this. You used to have to go to the main office or call them. You're supposed to be able to go to the local office. They've got access to the computer. They can call up your status and your license and walk you through what you need to do to get reinstated. It's gonna involve you taking care of these two outs, or three. You say you've already done the child support. You're gonna have to take care of Cabot County and Chesapeake. Then you'll have to pay a reinstatement fee. And, well, here's the problem. On this ticket, it says no proof of insurance. Did you have insurance?
This like Friday?
Yes.
No, sir.
Okay, well, that's gonna be a problem. I don't know, were you in here when I talked about the way it works in Ohio? You gotta have proof of insurance when you get a ticket. If you don't, the officer checks the box. When it goes to the DMV, they're gonna suspend you for not having insurance. In this state, if you're driving, you have to have responsibility because accidents happen. If you don't have insurance, you can't pay for the damages you caused to somebody else. And they're going to suspend you for not having proof of that. That's the way it works. So, sounds like we just need to go ahead and sentence you because I don't think, if you had a reasonable chance of getting your license back, I would let you try to do that.
It's going to take a lot.
It's going to take a lot. So I don't think it's going to happen anytime soon. Okay. Are you working?
Yes, sir.
What do you do?
I am the front desk receptionist down here at the Comfort Suites.
Okay. How do you get back and forth to work? You been driving?
I was driving.
Well, you don't have a license. I mean, you're suspended from driving, and you didn't have insurance, so.
Can I just add a little something about the no insurance thing? I know this sounds ridiculous because I still don't have a license, but I mean, actually, the vehicle I was driving is not usually the vehicle I was driving to work. It just so happened my door broke his, and I was in that specific vehicle I got pulled over in, which I usually don't drive. Just go figure.
Well, that's a problem because when you drive, it sounds like there was some problem with, did it have lights underneath?
Yes, underglow. Apparently, it's illegal to have them changing colors while you're driving down the road.
Yeah. So you picked the wrong vehicle to drive. I mean, maybe you didn't even know that, but.
No, I didn't know. I thought they were legal. He said they are. They just have to be a solid color, not red or blue.
It's like driving down the road with something saying, please stop me. Which you don't want to do. You don't want to say, please stop me. It's called probable cause. And then bad stuff starts happening after that. When you get probable cause to get stopped, then they start finding out stuff about you, like you didn't have a driver's license and you didn't have insurance. So better not to get in that situation. Okay, well, I'm sorry that's happened to you, and this is one more thing to throw on your pile of stuff that you got to take care of, but that's what I got to do. Okay? All right, so under the circumstances, I'm going to give you a small fine since I'm going to take you that you're telling me the truth. It wasn't your vehicle. I'll give you a $20 fine and court costs.
How much are court costs?
Well, $125.
I could pay on some of that today.
Okay. As long as you make an effort, look, if you don't even have to be here. People don't know this, and we get quite a few people watching now. We're on YouTube. All the court sessions are on YouTube. Because I feel like it is public, people should have a right to watch and see what happens. If you make any effort to get your stuff done, I'm going to work with you. Because I can fill out 3 jails with people that don't make any effort. So if you blow it off, you can go to jail over this. I don't want you to go to jail, and I don't want you to blow it off. I want you to take care of it, and I'll work with you because it sounds like you got a lot on your plate already. But you're going to have to, you got to do this. I mean, if you want to drive, you got to get licensed. I know it's a lot. You got kids?
Oh, yes.
How many?
2.
Okay, how old are they?
16 and 13 boys.
You got your hands full.
Absolutely.
So, but this is something you got to do. So try to take care of it. I'll give you a 10-day jail sentence, which I'll suspend. This is going to be hanging over your head.
Yes,
I don't want you to go to jail, but you got to take care of this stuff.
Yes, sir.
I'll give you a review hearing December the 8th. that's one way you can go to jail, is blow off your review hearing. If you don't come, I issue a warrant for everybody that can come to the review hearing. So you can make it jailable by doing that, and then the next time you get stopped, you go to jail. You don't just go home with a ticket, you go to jail. So your review hearing is December the 8th. They'll put you on probation for 2 years at level 5, which is non-reporting other than your review hearing. And you just have a fine and court cost to take care of. And then try to get your license.
Yes, sir. What time?
9 o'clock. And you gotta go check in with Mr. Major. He's gonna be your probation officer. To the left, as you leave the courtroom, is the probation office. Check in with him. He'll give you some paperwork. You're free to go. Don't forget about this.
Absolutely.
Okay.
Thanks, sir. Have a good night.
She said,
State of Ohio versus Spencer Johnson, case number CRA 25166.
all right, so you're Spencer Johnson?
Yes, sir.
Mr. Johnson is alleged that at Windsor Township on June the 4th, oh, this is an old case, June the 4th of 2023. Is that the right date? Because it was filed in March. It says 2023, but the case number is 2025.
The affidavit says 2023.
Yes.
Well,
We'll have to go with what it says. You can amend it later if you think it's the wrong date.
yeah.
June the 4th, 2023, it says you were knowingly in possession of some sort of psilocin mushrooms, a Schedule 1 controlled substance. That's a felony possession of drugs. Felony 5, maximum penalty is a year in jail, $2,500 fine. Do you understand the charge, sir?
Yes, sir.
And you've posted a bond already. Do you have the money to hire a lawyer?
I could come up with the money. It would take me a little bit, but I could come up with it.
Well, maybe I should ask it this way. Do you want to be considered for a court-appointed lawyer, or do you want to hire your own lawyer? If you want to be considered for a court-appointed lawyer, I have to ask you about your income. If you don't want to be considered, you want to hire your own, I don't have to ask you any questions about your income.
I'll hire my own.
Okay. How long do you think it would take you to hire a lawyer?
As long as you can give me.
Okay. Well, there's a little tension here between that, and let me explain it to you. Since it's a felony, these are so serious charges that they have to go to the grand jury. But you haven't been indicted by the grand jury, the complaint's been filed. But since it's so serious, I have to do, or you're entitled to a preliminary hearing within a certain time frame.
Yes.
If you're not indicted, you haven't been indicted. That's your right to have me look at it in a preliminary hearing. I can give you more time if you want more time to try to get a lawyer, but it would be 15 days. They have to bring it in for a preliminary hearing if you want it done within 15 days. If you want more time, I can give you more time, but it's your right to have the hearing within 15 days if you want. Do you want more time than 15 days, or you want heard within 15 days?
I'd like more time.
Okay. They'll still have to prove the case against you. It doesn't do anything to that. It's just the time frame for coming back for the first hearing. I'll give you more. And you said you want as much time as you can get. How about a month? You think that's sufficient? Can you get a lawyer?
I believe so, yes.
Okay. So let's set it for July the 11th. That's a Friday. Is that good?
Yes.
July the 11th will be your next hearing, so it's a little more than a month out. There'll be a preliminary hearing at 10 o'clock. Your bond that you posted is continued. And I'm putting down that you will hire an attorney. If you have any questions, you'll come back here for your next hearing on July 11th at 10 a.m.
No, sir. No
Unless
questions.
our lawyer says they may arrange this for a different date, you come to the date that they tell you. Because they can ask the court to change it if they have something else going on that day.
Yes, sir.
But otherwise, July 11th, 10 o'clock, if you can't get a lawyer by then, you need to show up and ask for more time, just don't blow it off, because you would get a warrant then for not showing up.
Yes, sir.
Any questions?
No, sir.
Okay, July 11th, 10 o'clock, next time.
I'll have a form for him to sign.
Okay, yeah, you'll need to sign, you're gonna sign a piece of paper that says you agree to the time going beyond 15 days. Mr. Hill's preparing that.
State of Ohio versus Mackenzie T. Webb, case number CRB 25340.
Ma'am, are you Mackenzie Webb?
I am.
Okay, you're receiving a copy of the charge. It's alleged that at Fayette Township on June 7th of 2025, you purposely tried to deprive Walmart of property without their consent. It's a first-degree misdemeanor theft offense. The maximum penalty for this is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand the rights you have?
Yes, Your Honor.
How do you wish to plead to this charge?
I plead guilty.
A guilty plea, excuse me, a guilty plea is an admission that the charge is true, and it waives your rights to have a trial and have a lawyer. Do you understand that?
Yes, Your Honor.
Okay, Mr. Hill, do you have a report on this case, Mackenzie Taylor Webb?
No, I don't have one.
Okay, I've got the affidavit is the only thing I have.
We can find our copy and it can be recalled if you want.
Okay. I'll recall you, let the prosecutor get their file, and I'll recall you, and they'll do the sentencing after that.
State of Ohio versus Kristen Orsbon, case number CRB 25338.
Ma'am, are you Kristen Orsbon?
Yes.
All right, you're being served a copy of the charge. It alleges that at Rome Township on June the 8th, you knowingly caused or tried to cause physical harm to Jeremy David Hensley, that he's either a member of your family or lives in your household. That's a first-degree misdemeanor domestic violence charge, maximum penalty, 6 months in jail, $1,000 fine. Okay, and I guess he's charged too, so we'll go ahead and call him.
State of Ohio versus Jeremy Hensley, case number CRB 25339.
And sir, are you Jeremy Hensley?
Yes, sir.
All right, you're being served a copy of the charge right now. It alleges that at Rome Township on June the 8th, you knowingly caused or tried to cause physical harm to Kristen Orsbon, who's either a member of your family or a member of your household. Both of you are charged with domestic violence. The maximum penalty for these charges is 6 months in jail, $1,000 fine. So you both understand the charge?
Yes, sir.
You both understand your rights?
Yes, sir.
How do you both plead?
Not guilty.
Not guilty.
You want lawyers appointed?
Yes, sir.
Are either one of you working?
Yes, sir.
Both of you are working? All right. Ms. Orsbon, what do you do?
I work at the Route 60 Walmart in Huntington. I'm a shopper.
Are you paid by the hour?
Yes.
How much per hour?
19,
How many hours a week?
32.
Okay. Do you have children?
Yes.
How many?
1.
So you're making about $30,000 a year gross, is that right?
Yep.
And what about you, Mr. Hensley? Are you working?
Yes, sir.
What do you do?
I also work at Route 61
All right, are you paid the same amount or different?
I'm paid different.
How much?
$14.26 an hour.
Okay, how many hours a week?
40.
You probably both qualify. Okay, I'll appoint Mr. Steyer to represent Ms. Horsbaum. And Mr. Morford to represent Mr. Hensley. They both have posted bonds, so the bonds are continued. Do either of you want order of protection for the other person to stay away from you?
Do you want an order of protection? Yes, stay away from me.
No.
None sought on Ms. Orsbon's side, Your Honor.
None sought here, Your Honor. Okay, no protection orders requested by either side. So you don't have to stay away from each other. It's your request. Not guilty plea is entered for both of you. And let's see. You can set this the 20th of June or after. Except for the 27th is already booked out. So
20th and 23rd, I'm on vacation. I'm here I've got a jury trial the 30th.
Let's go into July then.
Okay. Mondays are best for Ms. Orsbon. Unfortunately, that's going to mean the 14th is the early time available.
14th is good. Mr. Morford, can you do July 14th?
I can't judge. My client would rather have it on a Monday.
Well, they need to be here together.
I thought that's what we asked.
What I told him, Your Honor.
Did you say Friday? She said Monday, so I may have picked the wrong day.
That is a Monday.
That is a Monday, yes. July 14th is a Monday.
Yeah.
We'll set it for July 14th. You should be able to make, it's enough out that you should be able to make arrangements to get here. July 14th will be the next hearing. It'll be a pre-trial at 10 o'clock.
I'm sorry. No, hang on.
I'm going to keep these. I'll get them back to you.
State of Ohio versus Michael J. McKenzie, case number CRV 25337.
Let John serve those, Ron. Okay. So are you Michael McKenzie?
Yes, sir.
Mr. McKenzie, the state's alleging that Perry Township on June the 8th, you knowingly caused or tried to cause physical harm to Joseph K. McKenzie, who's either a member of your family or household. That's a domestic violence charge. It's a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. Do you understand these charges?
Yes, sir.
Do you understand the rights you have?
Yes.
How do you plead to this charge?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
My work is I take care of him daily with no pay. And my mother part-time.
What's the state's position on a protection order?
He has Alzheimer's.
Okay.
And
Joseph McKenzie has Alzheimer's?
Yes. The
Does
way
he have a guardian or anything?
Huh?
Does he have a guardian?
No.
What's the state's position on a protection order?
This may require us to reach out to find out from whoever else is there.
Is there somebody else in the household? Your mother?
Yes, my mother,
What's her name?
Bonnie. Bonnie, she's here.
She's here. Ma'am, if you would come up, talk to the prosecutor, please.
The way the house is set up, I live completely downstairs. It's a split level home. And they can't use the stairs usually. So the
Talk to
only thing
prosecutor, please, ma'am.
down there is me and the laundry room, but I do all the laundry. And this is a huge misunderstanding.
Such good care of me. It's fine. Just
Well, Your Honor, this is Mr. McKenzie's spouse. What's your name, Bonnie? Okay, so they all live in the same house. Apparently, Michael lives in a separate part of the
Now,
house.
which Mr.?
I'm sorry, Michael here, the defendant, lives in a separate part of the house and takes care of them. And Joseph McKenzie suffers from dementia. And according to Bonnie, Joseph wanted to leave in the car and had the keys to the car, and Michael tried to stop him, and a neighbor saw it and called the authorities. So I think that's where we stand. Now, that may be completely true or not completely true, but Bonnie says there's no need for a protection order at this time.
And state's agreeable with that?
I think under the circumstances.
Okay, so no protection order, you can stay in the house. And, well, I'll appoint counsel for you. I'll appoint Mr. Holt still here?
Yes.
Again. I'm going to appoint you to represent, this is Michael McKenzie, and it's a domestic violence situation involving his father, who has, I think everyone agrees, has some sort of dementia, Alzheimer's condition. So there's no protection order, because he's been taking care of him. He has posted a bond. The bond's continued. Not guilty plea is entered. When would you like to come back?
The same date, was it July, was it the 7th?
July 7 would be the next hearing. The pre-trial at 10 o'clock.
Yes. Yeah.
State of Ohio versus Caitlin Kelly, case number CRB 25336.
Okay.
July 7th.
Anything
July 7th.
Thank you.
You're welcome. All right, ma'am, are you Caitlin Kelly?
I am, Your Honor.
Thank you.
Would you write down your social security number on what Mr. Hall would you?
Just like on the back of this? Yeah.
One of those documents. That was missing in the request for that.
That's okay.
Okay, it's alleged that at Fayette Township on June the 7th, you purposely tried to deprive Walmart of property without their consent. That's a theft offense, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, Your Honor.
How do you plead to this charge?
Guilty.
Guilty means you're admitting it's true, and you're waiving the rights to have a trial and have a lawyer. You understand that?
Yes, Your Honor.
Okay. I'll accept your plea. Does the state have this file?
Yes, Your Honor.
Before I send you though, and I can go ahead and hear what the state has to say, but I will require a urine screen, but go ahead and.
You will require a what? I'm sorry.
Urine screen, I'm ready to do a urine screen before I actually send you.
Okay.
I want to hear what the state has to say.
Your Honor, this is Corporal Orsbaum from Lawrence County Sheriff's Office. June 7th, 2025, I was following up on a call at Walmart, once talking to loss prevention. They informed me that they had someone stealing. Upon watching the video, I saw both females putting things in their purse. After watching them check out, they walked past the last point to pay and went out the door. They were stopped and asked to step back into the office, and told they were caught on camera putting things in their purse. Both females stated that they did have things in their purse and turned them over to loss prevention. Loss prevention also stated they did not scan some of the items. Loss prevention is copying the video and will take it to the Chesapeake County Court. Both females were detained and then taken to the Lawrence County Jail for theft. The females identified themselves as Mackenzie Webb of Proctorville and Caitlin Kelly of Huntington.
All right, okay, ma'am. I'm gonna order you to do a urine screen. The reason I do that, over the years, I've dealt with a lot of these cases. And a huge percentage of people that I get shoplifting at Walmart also has substance use issues. So
Okay.
go do a urine screen, go to the probation office, they'll get you set up for a urine screen, and when I get the results, you'll get called and we'll do the sentencing then. So.
Okay, now I will say, Your Honor, I do have a medical marijuana card for the state of West Virginia. So I know that will show up. Does that?
Okay, we'll see what else shows up.
Okay, that's it.
Go do a urine screen.
All right, thank you, Your Honor.
You're welcome.
State of Ohio recalls Mackenzie Webb, case number CRB 25340.
Okay, so as I understand, this is a co-defendant, same report, so we heard that. So I'm going to also order you to do a urine screen, ma'am. So go do the urine screen, come back for sentencing once we get the results.
State of Ohio versus Craig Bowe, case number CRB 25310. Your Honor, this is a pretrial.
Okay, we finally finished the arraignments, so we're starting the pre-trials now.
They have some more arraignments.
He's in the Waters case set for pre-trial.
Yes, and he's in the lobby. I think several people
He
with
needs to be in the
pre-trials.
courtroom.
Well, I
Call
think,
the next case.
okay, I think several pre-trials.
Anybody's got a pre-trial needs to be in the courtroom.
Yeah, that's my fault.
With 100 cases, I have to wait 2 minutes for every person to come in. How much longer does that take to do the docket? Get in the courtroom.
State of Ohio versus Beth L. Christian, case number TRC 25661.
Get your clients in the courtroom. Talk to your clients. You don't have to just sit here. Talk to your clients. I was a lawyer. I know how this works. You don't have to go back in the conference room or sit out here. Talk to your clients and get them to do what they need to do. Be in the courtroom when their case gets called. I never go to any other court where this happens. I practice in Cabell County. I can't imagine what would happen if I said, wait a minute, Judge LaJoy, my client's sitting outside. He doesn't want to come in here and sit and wait on you. You got to wait on him to decide when he wants to come in the courtroom. That ain't happening. It never happens. It shouldn't happen here. You lawyers need to get on the ball. Talk to your clients. Make them do what they need to do. I'm tired of this. Show some respect to the court. Mr. Dwyer.
Your Honor, on Miss Christian's case, we're waiting on the video to be provided. We haven't received it yet. So we need that to have a meaningful pretrial. I've talked to the state about that. I expect they'll have that to me pretty soon.
Okay, how much time do you think you need?
Miss Christian works, she's got the 14th of July off if the court docket's not too busy that day.
July 14th will be the next pretrial. It'll be at 10 o'clock.
Thank you.
State of Ohio versus Travis M. Clark, case number TRC 25971, A and B.
Mr. July's case set for pretrial.
Your Honor, this is one that I think we're going to be able to get resolved. It's got a relatively low breath score. Discovery hasn't been completed yet. I told Mr. Heald that if we could get that discovery, I'd discuss with him a potential resolution. I believe the state's agreeable to that. It's an 084 on the actual breath.
Well, I don't know if that's within the mark. You know what the law is now.
Right, and that's what we're trying to determine from the discovery. We don't have it all yet.
Deviation from the known solution. So what date do you want?
I don't think it'll take long to get that information, the 30th or the 14th, whatever the court has room for.
June 30th is the next hearing.
Yeah, June 30th, don't forget.
State of Ohio versus Brandon P. Tate, case number TRC 25998, A and B.
Mr. Gallardo's case set for pretrial.
So I've talked to the state about this one too, Judge. In this case, there was an automobile accident. Mr. Haight indicates that he was struck by someone, an erratic driver. There is apparently a witness that called in an erratic driver. We don't know the identity of that witness, so we're going to have to try to ascertain that. Mr. Heald's indicated to me he would reach out to the Highway Patrol Post to see if they have any contact information related to that person. Mr. Haight was charged with an OVI, but this was in the middle of the workday. The only test was a HGN where he exhibited no clues. But he was knocked pretty loopy in the accident. He hit a concrete barrier and it was a bad ordeal. So we're trying to figure out if this witness can confirm that there was an erratic driver that struck him in the rear of his car that caused him to crash.
Okay, run over that with me again. I was reading the report.
Okay, so Mr. Haight was involved in a pretty bad car accident. According to Mr. Haight, he was struck in the rear end, and it caused him to strike a concrete barrier. He wound up crossing traffic. There were two other cars impacted in the accident. He was banged up really bad. They were able to do an HGN test, which demonstrated 0 clues. They were not able to do any other standard field sobriety tests. They charged Mr. Haight with...
They asked him to take a urine screen, and he refused.
Did you go to the hospital?
No.
He
That's
doesn't.
what's in the report.
Well, I know, and he doesn't recall a lot of it. He was banged up pretty bad.
Your Honor, in addition, and I think this is what Mr. DeLauder was getting at, is that apparently there was a call made previous
About a white pickup truck?
About being all over the road, and I want to find out who that person was because they would be a witness to the erratic driving.
Was this the white pickup truck or was somebody else in the
Well,
white pickup truck?
that we need to find out. So there are some questions. So we've promised to try to find that out as quickly as possible.
Yeah, it looks like Mr. Haight was driving a white pickup truck.
He was, Your Honor. It was in the middle of his workday.
So it sounds like we need to have the officer here for a pretrial.
Yeah, that'd be fine.
Would that be helpful?
Probably,
Would be
yes.
helpful. Also, the person who called originally that said that the erratic driving was going on, I'd like to know who they are,
If they have that information.
if they have that information, yes.
Well, it sounds like if you had the officer here, that would be very helpful to getting to the root of some of these issues. So can we have that happen this next pre-trial?
We will make every effort to do that, Your Honor.
Well, it should be pretty easy. You give them a subpoena and they gotta be here. Again, I mean, give them a subpoena and tell them they have to be here. It's not like optional. It's mandatory. Okay. What date?
Judge, I'm scheduled to be here on the 30th and the 14th are the next 2 dates I've got a
Let's
trial.
do the 30th.
Okay.
June 30th will be the next pre-trial. That's plenty of time to get the officers here. June 30th? 10 o'clock.
State of Ohio versus KCR Hudson, case number TRC 25-1010, A and B.
This is Mr. Delauder's case set for pre-trial.
Your Honor, we are working on a proposed resolution on this one too. The issue in this case is there was a portable breath test done at the time of the stop that rendered a score that was under the legal limit. However, by the time this gentleman got to the post to do the actual breath test on the machine, it rendered a result that was over the legal limit. I think the state is considering a proposal I made to resolve it, which would involve Mr. Hudson completing the driving school and in return an amendment of the charge of reckless driving. I think they want to speak to the trooper or potentially further evaluate the facts before making that decision. I don't think Mr. Hill's had an opportunity to look at the video yet to see how my client did on field sobriety tests. However, he indicates to me that he did very well on the field sobriety test and doesn't think he exhibited any indications of impairment.
So I agree. Again, this would be another case that would be very helpful to either have the officer here or have a discussion with him before you decide how you're going to proceed. So you want to do the same date as the other?
Yes, we can. We can do that, Judge. That'd be fine.
June 30th. 10 o'clock for the pre-trial.
State of Ohio versus Ricky May, case number CRV 25-185, A and B.
This is Mr. Delauder's case set for pre-trial.
Excuse me.
So, Your Honor, I think we've got an agreement.
Want to say what that is?
We've agreed to amend the charge to an assault, a misdemeanor assault, upon his agreement to plead guilty to that, and our recommendation will be 60 days in jail suspended, 2 years probation. We didn't talk about a fine, but we would want court costs, and we would not be opposed to a fine if the court ordered that. We're also going to want a no contact order. Now, here's the thing about that. The no contact order is good as long as he's on probation. So we want the probation term to go out the 2 years.
Yeah, I think have an ORC number for the limited protection.
Yeah. Look at the assault, hold on.
Yes.
So that would be the domestic is going to be amended to assault. The A case.
I believe it's 290313.
That's correct.
Is that coming up right now?
Yes, yes, thank you.
So I'm reading the affidavit. So the two of you have children together? So how is this going to work with the no contact order and we have minor children?
Do you have somebody that provides the transportation?
Does he have custody?
Well, not right, not, they recently were ordered to do shared parenting, Judge, so they've got shared parenting.
So there is an order now. There apparently wasn't any order when this was happened.
That's happened since then. And the protection order that was issued, the CPO that's referenced, has also, that's been dismissed at this point. So that doesn't exist anymore, and they have a shared parenting order.
Is the shared parenting order out of our jurisdiction?
Oh, no, it's not.
Kentucky,
Yeah.
Boyd County.
Yeah, Boyd County.
Okay. Anything else? And this is Haley Corwin, right?
Yes.
Anything you want to tell me about this now?
I am scared for him to continue to do something worse. We're on top of not being cooperative about sharing our children. It's taken him a couple tries since the order went into place. He's shown up at the house for unnecessary reasons. I communicated with him about something to do with our son's inhaler. I said I'd had it taken care of, but no, he called the ambulance and the police over. He's posted all kinds of things on the internet about me. It makes me scared that he's going to continue to go further until something is, something's going to happen. And, I get scared to go out sometimes because I'm afraid I'm going to be out with the kids and he's either going to start trouble or he's going to try and take him even though we have the order. I don't know. He's unpredictable to me, so it just makes me nervous.
Well, what's been recommended to the court is a change of the charge from domestic violence to assault. Are you on board with that, or was that discussed with you, or you just told us what was going to happen?
He discussed it with me. As long as I get the protection order, as long as he serves his sentence, as long as he does stay away, and we continue to make progress with our custody order, I'm okay with that.
Okay. Well, it's certainly complicated by the fact that you've got two children together, and I'm assuming they're younger, and they're going to have a relationship with both of you, and so they're going to have some times when you're going to be around each other because of these children. That kind of joins you for life. Once you have kids together, there's always going to be, there are little league games and school and eventually weddings and funerals and there's all kinds of stuff that you have to try to work out some way to coexist together. You understand that?
I do.
And I'm not apologizing and saying if he is treating you poorly or threatening you or making you feel unsafe, that that's justified. It's not. If you didn't want the domestic violence dismissed, I wouldn't dismiss it. We could have a trial or proceed under that charge. Do you understand that?
I do.
Judge, they've only had one, the shared parenting's relatively new.
Well, that's what I was thinking. If you wanted more time to see if it was going to work out, I could let it pen longer and see what happens. And then if it doesn't work well, we can come back for a trial.
They've only had one exchange so far under the shared parenting arrangement. We don't care either way.
We were supposed to have 4 exchanges at this point. And I saw the other day where he told somebody that I was just awarded visitation on the 2nd, but really it was on the 30th. At first he tried to act like he didn't get the order. Then he didn't listen to his lawyer. Then he finally did listen to his order. And
well, maybe we need to let this pen for a while longer and see how things are going to go. It means you have to come back to court, but it maybe shouldn't be amended to an assault rather than domestic violence if there's not going to be cooperation.
That's fine with us, Judge. You want to set it out about 60 days and just make sure everything's fine, that's fine.
I want to see what she says.
Okay.
like, can I still get a protection order in place?
You can get a temporary protection. In fact, I think you have one already.
I don't see one in the file that I can issue you a protection order. Subject to your shared parenting.
Right, I believe if we have to, is it guardian ad litem, if we have to hire somebody, or, I mean, I could figure out a way to make that work in place.
Well, you don't necessarily have to hire someone, but what could happen if you can agree that there's a third party that can assist in the transfer of the children, so it could be more of a neutral person that's involved, or somebody like that can help.
Yes, I'm sure I can figure that out. I'm okay
Okay,
with
so
that.
you want more time then, see how this is going to work out? Is that correct? You want more time?
Yes.
Okay. So, do you need 60 days? Think that's too long, or?
I don't need 60 days.
30 days?
30 days is good with me.
Mr. Dwyer?
July,
a month out.
July 14th, okay?
Yes. All right, so I'll set it for another pre-trial on July 14th. I will issue a protection order today, subject to the whatever protection orders are in effect and shared parenting. So, and this is the other thing I would direct. Don't post things about the other person on the internet. Don't make comments about them or try to get, I don't know, I'm not going to prejudge, but I see this all the time. People post videos, they post stuff, trying to make the other side look bad or get sympathy for what they're going through. No, I don't want to see any of that. July 14th will be the next hearing, will be a pre-trial at 10 o'clock.
Thank you, Alan.
You're welcome.
Yeah, 2 places for assistant and 2 places, yeah.
State of Ohio versus Bryce McGinnis, case number CRA 25299, CRT 25987.
Mr. Delars, please.
Your Honor, this case involves a motorcycle that was purchased off of Facebook Marketplace. I've shared with Mr. Heald some discovery that I have involving that transaction and the parties involved and sort of the history of it. I'm also, after speaking with Mr. Heald, going to have my client swear out an affidavit that explains the history of the transaction and provides contact information for the other parties involved. I think that'll wind up resolving the matter as far as Mr. McGinnis is concerned. So if we can have one more pretrial, I think this will be over with. This is the first time we've been to court on this.
June 30th?
That's fine, yes.
June 30th will be the next pretrial and preliminary hearing. Preliminary hearing and pretrial, 10 o'clock.
State of Ohio versus Marissa Pauley, case number TRC 25-613 A and B, CRB 25-297.
Your Honor, we were able to obtain the chemical results in this case. They only showed THC. I think based on the results and the remaining allegations, the state's willing to dismiss the endangering children charge. However, Ms. Pauley intends to enter a guilty plea to the OVI.
And we did receive the results back, Your Honor, and it was the THC was the only thing in the test. And so we would be willing, if she pleases the OVI, to dismiss the endangering charge.
What was the levels on the marijuana?
It was just reported as over the, in excess of 200 nanograms per milliliters, and they don't really specify other than over that limit.
All right, Ms. Pauley, do you agree with what your attorney has represented to the board?
Yes.
Do you have anything you wish to say before sentencing? You don't have to, but you have the right to make a statement if you want. So that's a no.
No.
Judge, for your information, I don't know if it matters a whole lot to you, but Ms. Polly doesn't have any kind of criminal record. She's also recently been accepted into the nursing program and is anxious to start that, so she's got her life kind of going in the right direction other than this. I think she's also quit smoking at this point, so.
Okay, it seems like, from what I'm read in the report, you were pretty high, and you got stopped. I'll impose a $500 fine, or cost be paid, 20 days in jail suspended, 5 days community service, requiring you to go to the driver intervention program, 2 years of level 4 probation. The review hearing will be December the 8th of this year. She's asking for limited driving privileges.
Limited, Your Honor, yes, just for school, community service, and court purposes.
Okay, she can have driving privileges for those reasons. Now add childcare. We have 3 children.
Thank you.
On the lane violation, $20 fine.
Thank you.
So we'll dismiss the child endangering. She'll need to see Mr. Major in probation before she leaves.
All right, she'll do that now, Judge. Thank you.
Thanks.
We're good.
State of Ohio versus Timothy Sanders, here at court, case number CRA 2584.
Mr. Waters' case. It's actually a preliminary hearing. He's at RRS.
Yes. Your Honor, maybe my notes are incorrect here. I have a note that Mr. Sanders pled to that charge was reduced to an M1 theft. Mr. Sanders has entered a plea.
So it should be actually, it's a sentence.
I believe so. And I've discussed the matter with Mr. Heald. I think, given Mr. Sanders' continued very successful efforts at treatment, I believe Mr. Heald's willing to proceed with sentencing today, if the court is.
Okay, so it's a very good report.
He's been in treatment, Judge, for, I think, since March, sometime in March.
March 11th.
Okay.
Okay, go ahead and do sentencing. Is there anything?
Sorry, it really was the original charge.
It was an F5. So now it's reduced in M1.
Judge, I believe the state is willing to resolve this with the recommendation of 60 days in jail. But that time will be suspended on a strict condition that Mr. Sanders remain compliant with treatment. And it's my understanding from speaking with Mr. Heald that in the event Mr. Sanders will become uncompliant with treatment, the state will be seeking imposition of the entirety of that time.
That's correct.
Mr. Sanders, do you have anything you wish to say?
No.
Okay, I'll impose what was recommended. I'll make it a $500 fine and suspend $400 if you complete treatment. So it'll be a $100 fine rather than $500 fine if you complete treatment.
Okay.
60 days in jail, all suspended on the further condition that you complete your treatment. And I'll set, and the treatment is at RRS, you're complete there. I'll set a review hearing for you in a little over a month. We'll set it for July 21st. It'll be your first review hearing. You'll need to meet with Mr. Major about your probation and get your paperwork from him, and then continue with the treatment. Be back here July 21st, 9 o'clock for your review hearing.
I won't be here with the review. Thank you, Your Honor.
You're welcome.
State of Ohio versus Stanley D. Bennett at the Lawrence County Jail. Case number CRA 25342, CRB 25343, PRD 251319.
Sir, are you Stanley Bennett? Can you hear me okay, Mr. Bennett? Yes, sir. I'm Judge Capper at the Lawrence County Municipal Court, which is in Chesapeake. That's where your case is filed, and this is what's called an arraignment hearing for you. The purpose of which is to tell you the charges and take a plea and sign counsel and that sort of thing. So you have a right to remain silent. You don't have to say anything. If you do make statements, they're on the record. They can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, and to have bail and make the state prove the charges against you beyond a reasonable doubt. Do you understand those things? Yes, sir. The most serious charge is case number 25342, aggravated possession of drugs. It's alleged that Stanley Bennett at Rome Township, June 7th, knowingly possessed or used a controlled substance, being methamphetamine, in an amount exceeding the bulk amount. That's felony 3. Maximum penalty is 5 years in jail and an $8,000 fine. Then there's some misdemeanor traffic charges also. 251319A is a driving under suspension. It's alleged you were driving a motor vehicle June 7th in Rome Township at 9:29 p.m. Driving under suspension as charged is a first-degree misdemeanor. Maximum penalty is 6 months in jail, $1,000 fine. You're also charged with having expired plates on the vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine. And having the wrong plates on the vehicle, fictitious plates. They go to another vehicle. That's a 4th-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand these charges? Yes, sir. Do you have the money to hire a lawyer? No, I don't.
Your Honor, he may have a bench warrant too, I'm not sure, and it's a different social work, it's up under this,
Okay.
RC 2015-22.
All right, we may have we're checking to see, we may have a warrant for you on an old case also, so we'll pull that and let you know. Okay. Do you have a job, Mr. Bennett? No, not too long ago. You have no income coming in at all? No, I do side work, side jobs when I can. How much do you make in an average week doing that? A couple hundred a week or so. I'll appoint Mr. Steyer to represent you. He's in the courtroom now. He's heard your arraignment so far. Okay. What's the state's position on bond for Mr. Bennett? And it appears that he may have an older case that he failed to appear on also. They're looking for the file.
Notwithstanding whatever the outcome will be of that other warrant, or if there is one, we, in order for him to get out of jail, we want him to be assessed for some treatment.
So you'd be agreeable to a signature bond if you would agree to go to treatment?
Yes, Your Honor.
Do you, sir, where do you reside?
4198 County Road 12.
So in Ohio. Do you have a medical card, sir?
I think it's still valid. I think so.
Okay. Are you willing to be assessed if we can get someone to speak to you?
Yes, sir.
All right. Is there anyone who would be willing to speak? No, by the court.
All right, Mr. Quan raised his hand first, and I'll let, you want to talk to him at the jail on the phone? Yes, sir. Okay, so we're going to have a treatment provider call down, talk to you, do an assessment of you. And the way this works, if I agree to it, you're going to get out on your promise to come to court as ordered, and you're charged with a felony, so there's no place you can hide. If you decide, I don't want to go to treatment, I'm just going to leave and go to Huntington. We have people do that. Warrant's going to be good in Huntington because it's a felony. So you get picked up over there, you're going to go to Western Regional Jail, and you're going to sit there for at least 3 weeks. It's about how long it takes for you to get in front of the judge in Cabell County, and then you'll come back here. So you're just be wasting time sitting in jail.
Yes, sir.
So this is an opportunity for you to get clean, but you have to want to get clean. You're going to have to do what's set out for you. If you don't, then you can go to prison on this charge. It is a felony. So if you blow everything off, worst case scenario, then you get convicted. A felony 3, you can go to jail for prison. Let me change that. You can go to prison for quite a while. Not jail. Jail's at Ironton. Okay, and now I do have your old charges, so we'll add those to the mix. 23-163 and 2646, 2015-22. So 23.
Are these post-conviction or still open, Your Honor?
This one is still open. 23-163 is failure to provide for a functionally impaired person. And it looks like he never appeared on it or was arraigned on this charge.
We'll waive reading in or not guilty plea, Your Honor.
It's an M2. I don't know if I've ever had this charge before.
And I would ask that whatever there is pending, all be covered under a single bond once we know what that's going to be.
The others are, it looks like, still pending too. Mr. Smith, Roger Smith was the attorney on this. He had a felony and an OVI. He pled guilty to the OVI. He was supposed to be going to treatment. It looks like his last time for appearing was January the 6th of 23, so they need a GPS monitor.
Sounds like it.
Do we know what the status on those is at the moment?
Still pending. He pled guilty to the OVI. He never got sentenced. He was supposed to be going to treatment.
I'm sorry, I meant what the status of our GPS monitors is.
Oh, I'm not sure.
Well, I'll speak to Mr. Major and find that out.
I'm looking to see,
Rather than have CRA 2646 and 5.
yes, 2646 was that a possession? Yeah, it was. He had a prior possession and an OVI. So, I'm only going to agree to you going to treatment with an ankle monitor. So that makes you're agreeable with that? Well, but let me explain. That ups the ante even more than what I said before. So this is really important that you listen up and understand what I'm telling you. Because now, once if I put an ankle monitor on you, the only way to get away from that is to cut it off.
Yes, sir.
And that's hard to do, but it is possible. We've had people cut the ankle monitor.
Yes, sir.
That's going to result in you getting a more serious charge, and we've only had a few people do it, maybe 5 or 6. They've all gone to prison. So if you do want to go to prison, the guaranteed way to do it is to cut the ankle monitor off, because adult probation, which is the probation office for the common police court, they're going to place the ankle monitor on you, and they're going to supervise you. They get really mad when people cut the ankle monitors off, so they try to come up with the most serious charge they can to file against you, and it takes it out of my hands. You won't even be in front of me anymore. You're going to go down to common police court, and everybody that's done it has gone to prison. And I'm not talking about for 6 months or a year. The least I know that anybody went to prison for cutting an ankle monitor off is It's 3 years.
Yeah, that's what I heard as well.
Okay, word's out. So, once I place an ankle monitor on you, you gotta stay. Unless you're really dumb, and we have some really dumb people, because I've had this same speech I've given to people, and I had one guy who wanted to go to a party in Charleston. He cut the ankle monitor off, went to and he just got out of prison here recently. He was in for at least 3 years. So it must have been a hell of a party.
Yeah, right.
Party, 3 years in prison.
Yeah.
Not a good decision. Okay, so you're gonna at least tell me you're gonna stay and go to treatment, right?
Oh, yes, sir.
I've never had anybody yet say, oh, Judge, I'm gonna cut that ankle monitor off. But still some of them do it, and even after hearing all this, they still do it.
Yeah.
It's amazing to me. I don't understand the thinking, but I guess addiction is powerful. So, we'll let Mr. Pond talk to him, and I'm going to assume that he's going to be admissible. If he's not, then you let me know, we'll come back and redo it. So I'm going to enter an order that he can be released to Southern Hope with an ankle monitor when one's available. The other thing is, I can't guarantee you there's ankle monitor available today. It may take a few days to get one.
Okay.
I'm available Friday and Monday, Your Honor, and then I'm going to be gone until the 27th.
Okay, we'll get him in here one of those days. Let's see. Actually, Friday's better than Monday. Monday's really bad. Friday's better. I'm going to put you on the docket for Friday. Hopefully you'll be in treatment then, and we'll get confirmation of that. If they won't accept you, then we'll come back. I'll be back on the monitor later today, and we'll talk about maybe other options if there's another agency that would be willing to take you. $2,000 signature bond. Next hearing June, on all of his cases, June 13th. Released only to Southern Hope with GPS. You want the files, Mr.
If I could, Your Honor.
State of Ohio versus William Earls, case number CRA 25187, CRB 25188, CRB 24788. Christopher Faulkner will be on deck.
Okay, Mr. Earls is at the jail appearing by teleconference. Mr. Morford is here. He has been evaluated now, but we don't have a report yet.
That's correct. It was last week, late last week, Judge.
So we'll have to continue it to get the report. From what I understand, it's going to be probably at least the 23rd before the report's issued.
I would say at least.
Are you available the 23rd?
Yes, sir.
All right, Mr. Earl's next hearing will be June 23rd on both his cases at 10 o'clock.
Thank you.
Will not.
Thank you, Your Honor.
State of Ohio versus Christopher Faulkner, case number CRB 25335, A, B, and C, and CRA 25334.
All right, Mr. Faulkner, can you hear me, Mr. Faulkner? Sure. I'm Judge Capper at Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing, purpose of which is to tell you what your charges are, to take a plea from you, and decide how to handle your case. You need to understand the charges, even if you don't agree with them. You have a right to remain silent. You don't have to say anything. But what you do say is all being recorded in your audio and your video, so you get both being recorded. You have the right to have a lawyer, to talk to a lawyer, and have one appointed to represent you if you can't afford one. You have a right to bail and to make the state of Ohio prove any charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
Your charge, there's two charges here, it looks like. 25, 335, well, maybe three, A, B, and C. The A case alleges that at Fayette Township on June 6, you purposely tried to deprive Lowe's of property without their consent. That's a theft offense, maximum penalty 6 months in jail, $1,000 fine. 335B alleges that the same day you tried to deprive Walmart of property without their consent, also a theft offense, maximum penalty 6 months in jail, $1,000 fine. And then the C case is a trespassing, where it's alleged you entered the premises of Walmart without their consent. That's a fourth degree misdemeanor, maximum penalty is 30 days in jail, $250 fine. Do you understand these charges?
Yes, sir.
Then there's also something from out of state. Case number 25-334. It's alleged that there's a warrant for you issued by Kentucky, Lawrence County, Kentucky District Court, on a theft offense out of that court, asking that you be extradited to that court on these charges. So that's in the mix here too that we will have to deal with. You have a right to have an attorney on all these things, and to have one appointed if you can't afford one. How do you plead to the charges in Ohio, the two theft offenses and the criminal trespass?
Guilty, sir.
Do you want a lawyer on the Kentucky extradition matter where they're asking you be returned to Lawrence County, Kentucky?
Yeah, I suppose I don't really know how that works. I've never had to deal with it.
Well, you have a right to it's called an extradition hearing. Kentucky issues a warrant for you, goes to the governor of Ohio. The governor can then decide whether you should be sent a warrant down here to send you over to Kentucky. And you have a right to have an evidentiary hearing about that, not on whether you did or didn't do the theft offense in Kentucky, but whether there's good cause to send you to that jurisdiction. I'm happy to give you that hearing if you want, and appoint a lawyer for you, but it won't resolve the theft offense. It'll just be about whether I should send you to Kentucky.
Yeah, I posted a bill here on Friday night and they ended up holding me because of still now. I don't know if it's been the same 2 hours or however long it's been. I don't know how long they're allowed to hold me for that. So I guess they're still holding me for it.
They're holding you because you posted bond on the theft and criminal trespass here in our state, but there's a holder from Kentucky, and I haven't set a bond on that, and maybe I would. Let me look at it and see. It doesn't say. Sometimes they'll say they don't want bond, and I don't necessarily have to honor that. I'll set bond on this based on what I'm seeing was the basis. It's like $1,500, looks like the theft amount. So I will set a $1,500 additional bond on the Kentucky charge. Do you think you can post that?
Is it $1,500 cash or?
Cash or surety. So if you got $1,500 in cash you want to post with the clerk, then it'll sit here until you go turn yourself in. I'll give you a time frame to turn yourself in Kentucky. If you do it, then you get the whole $1,500 back. If you can't post $1,500 in cash, I'll let you use a bail bondsman. So they guarantee your appearance in Lawrence County, Kentucky, and you pay them the fee, but you lose the fee. Then if you don't show up in Lawrence County, Kentucky, they're going to have to pay the court $1,500, and bail bondsmen don't like to pay the $1,500. So they're going to usually come and track you down, try to nab you and take you to the jailhouse. So,
If I could do it through a bond, I'd appreciate maybe the same one I've already used.
okay, so you want to talk, Mr. Sally, you want to talk to him about posting this bond on Kentucky. I'll set it at $1,500, cash or surety on the Kentucky matter. Let's go ahead and sentence you on the Ohio things since you pled guilty to them, and I'll come back and we'll talk about the Kentucky matter then after I've sentenced you. So is there anything you want to tell me about these theft offenses?
No, sir, I was in the wrong.
Okay, let me...
I just lost my job. I didn't have an excuse for it, but as I said, I was in the wrong. I lost my job. I'm trying to take care of my child, my newborn child. I don't know. This is a mess.
I've got an affidavit from Deputy Atkins, Lawrence County Sheriff's Office, that says, June 6th, I was dispatched to Walmart reference to an active theft in progress. While en route, dispatched advised Walmart loss prevention. Reported the male had exited the store, left in a silver Mazda, was heading toward Lowe's. When I arrived at Walmart, I did not initially observe the vehicle and made contact with Walmart. Loss prevention showed me surveillance footage confirming suspect wearing blue coveralls, reflective stripe, left the parking lot direction of Lowe's. The located silver Mazda at Lowe's unoccupied. Shortly after Lowe's personnel informed me the same male had entered their store, was walking around selecting merchandise. Positioned my cruiser along the side of the lot to maintain visual surveillance, waiting to see if he would attempt another theft. I made contact by phone with Lowe's staff who monitored the suspect by security cameras. The male had items in his possessions. They suspected he had concealed them. He exited through the lumber department doors. We stopped the male in the parking lot as he was walking toward his Mazda. Advised him he was under arrest for the Walmart theft. When I searched him incident to arrest, I recovered multiple stolen items concealed in his jacket. He was identified as Christopher Faulkner. I read him his Miranda rights. He admitted taking the items, claiming to do so because he had a newborn baby at home. Took possession of recovered merchandise, total value $108.90. Lowe's confirmed they wished to pursue charges. Transported him back to Walmart. Total merchandise there was $128.19. They advised he had been previously convicted in Ashland and Barbersville, so they wanted a criminal trespassing. Transported to jail. Okay. Do you have a drug problem?
No, sir.
Okay. Well, I'm going to make you do a urine screen. That's my usual. Do a urine screen there to jail. I'll get the results and we'll go from there. But how old's your baby?
She was born a month early, sir. She's just probably 2 weeks old.
Well, really bad decision because you got not only this, but now you got to go to Kentucky and deal with the issues you got over there. So I'd urge you to get things cleared up and be a father to this child. She's going to need you. It's a tough world out there. And let me just say this. One of the things we know, you ever heard of ACEs, Adverse Childhood Experiences? It's one of the things that can predict trouble for kids down the road. Trouble like substance use issues. One of the major adverse childhood experiences is having a parent in jail. That's an adverse childhood experience. People that have adverse childhood experiences, and they kind of add them up. The more you have, the more likely you are going to wind up in criminal trouble, substance use, problems in your life. So get your life. I mean, you're still a young guy. How old are you?
36, sir.
Well, compared to me, you're pretty young. But you're a full-grown man. At 36, you're a full-grown man. Start acting like one. Take some responsibility. You got another life that you brought into this world that you're responsible for. Take some ownership of that. Provide a good life for that kid, and don't keep messing up.
Yes, sir.
So go do your urine screen. I'll see you back once we get the results.
Okay.
State of Ohio versus Danielle Ham at the Lawrence County Jail, case number TRB 25-298, A, B, C, and D. Carolyn Jacks will be on today.
Danielle Ham is Mr. Morford's case, and this is set for pretrial for that.
Judge, I'm
Waiting
going
for
to
her
ask
to
you,
get a GPS monitor, I think, one week.
Your Honor, they didn't have a monitor available for her, and she refused the monitor, stating that she didn't want to do that long treatment.
Okay. Is that correct, Ms. Ham?
Yes, sir. There was an email there that she had just put my previous charges on me, and I didn't want to go to that facility with her, Laura Thompson.
She's not there.
Welfare, was she ever there, or?
She was at one point. She's only there for like 2 days.
Okay, she's not there anymore.
But I don't want to go, I would like to go to Southern Hope if that's possible, Your Honor.
Okay, why don't you want to go to Bethesda?
Because I've already been there, and Your Honor, I just messed up one time. I feel like I should just brush my knees off, go get my supplement shot again, and get back on track. I don't feel like,
Well, you know what, you don't get to make that decision, you got new charges.
yes, I understand that, Your Honor.
So you don't get to go commit the offense and then come into court and tell the judge what sentence you want.
No, I wasn't trying to do that. I was just
Well,
saying,
you did.
I believe how they believe, and I just would rather go to a different facility.
Okay. Mr. Morford, Mr. Yield?
Well, if the counseling agencies are willing to talk about doing that, then we just want her to get the help that she needs.
Yes, sir.
So I don't know if any of the agencies are willing to take her.
Well, one thing I don't like to let defendants do is pick where they're going to go, especially when I've told them to go someplace else. So I'm willing to send you to the counseling center.
Okay.
You willing to go there?
Yes, sir.
And that's going to be in Portsmouth.
Okay, that's fine.
All right, Mr. Tarvin will call down, assess you. I'm going to assume she was admissible to Bethesda.
So is there a case other than the 25-298?
That's what it is, 25-298. So I'm going to order her released with the GPS monitor to the counseling center. And then
Is that a 2,000 I've already run?
yeah, it was 2,500, I think. Then come back in a week.
we should, Judge.
The 16th.
I'm good.
Okay.
Your Honor, if I may, her refusing to have the ankle monitor put on puts her at the end of the list. I think we have at least one, maybe two ahead of her.
Okay.
Oh,
Actions have consequences. You refused to go before, and now you're back at the end of the list.
do you know about how long that would be?
I don't. My crystal ball up here is not working. So Mr. Major says there's a few people ahead of you, usually a few days, I don't know. If my crystal ball was working, I'd say, what's the Powerball number going to be? So, but I'd say, I think I can predict, hopefully by next week you'll be there. But you sat in jail at your own choosing for a while now, because you could have went to Bethesda, but you didn't want to go there. So, now you go to the counseling center if they agree to take you.
What type of place is that? I don't know anything
It's
about
very good. It's one of the first agencies in this area to do the type of treatment that's very well established and respected. So it's a good place. If you want to get clean, it's a good place to go to get clean. I've had a lot of people go there and be successful.
Okay.
Good luck. We'll see you in a week, Danielle.
Okay, next hearing, June 16th.
Thank you.
Here, Butch.
State of Ohio versus Carolyn Jacks, case number CRE 25-341, and Terry Markham will be on deck.
Carolyn Jacks.
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake.
Yes, sir.
I'm sorry?
I can't hear you.
Okay, let's turn up your volume a little bit.
Okay, that's okay.
Can you hear it now?
Yes, sir.
I'm the judge of your case. Right now, it's filed in Chesapeake at the court there. You're appearing on a monitor in the courtroom, so everything you say, everything I say is all being recorded. You don't have to say anything. You have a right to remain silent. You have a right to have an attorney, to have one appointed to represent you if you can't afford one. You have a right to bail and to make the state of Ohio prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You're charged with possession of cocaine. It's a felony of the 5th degree. The state's alleging that in Perry Township, June the 6th, you knowingly obtained or possessed a controlled substance, and that controlled substance was cocaine. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. Do you understand that charge?
Yes, sir.
Do you have the money to hire a lawyer?
Yes, sir. I think, well,
So you want to hire your own lawyer rather than me appointed?
well, the thing, I can't even court appointed lawyer, because
Do you have a
my
job?
husband on the boat, I can't really get in touch with him, so yes, I think I need to court appointed.
Do you have any income?
At this time, I was supposed to start a program next week down in Huntington as a nurse's assistant, but I'm here now, so I don't know if that's going to happen.
Okay, I'll appoint,
Can you turn me up a little bit more?
I'll appoint Mr. Holt to represent you.
Okay. Mr. Hope, okay.
He's here, we'll get him in the courtroom. This is a F5 possession of cocaine charge. Carolyn Jacks is the name of the defendant. State's position on bond for Ms. Jacks.
Your Honor, we would not be opposed to an OR bond if Ms. Jacks were to be assessed for treatment that she would enter into upon her release from jail.
Did you hear that, ma'am?
Yes, sir.
Are you interested in that?
100%.
Okay. Do you have a medical card?
No, I don't have that card.
Have you ever had a medical card?
No, sir.
Do you have medical insurance?
Yes, sir.
From what type of medical insurance do you have?
Don't quote me on this. If I'm not mistaken, it's Blue Cross Blue Shield. If I just put this in there real quick, then my husband has been having problems, so he's trying to do job, so I haven't been home for a while. But I get all the information. We're going through, a little rough patch here. So, but I do have insurance,
So is that through his employment?
Sir?
Is the insurance through your husband's employment?
Yes, sir. Yes, sir.
Well, believe it or not, that makes it hard.
Makes it harder?
There's fewer facilities that are set up to take medical insurance.
Okay, we do what I just did.
Well, yeah, we gotta get you treated, and we can't get you treated if you don't have coverage. Probably OVP, unfortunately, we don't have anybody here from OVP today.
Well, I don't even know, honestly, I've been away, I don't know, maybe you don't even have it.
Your Honor, she's incarcerated. I won't be able to be back here till early July.
Oh, okay. Well, Mr. Morford, I'll appoint you then in that case. I'm going to appoint you a different lawyer because Mr. Holt can't be here for a while, so I'll appoint Mr. Morford. I've got a Pomeroy address for you, ma'am, is that right?
Yes, ma'am. Yes, I will, yes.
Okay.
Like I say, you're on the front past. I was saying, bring that in.
Have you ever had a medical card, Medicaid card?
Well, mean, he's working, so I was sure.
Can you, Mr. Morford, can you contact OVP? Usually Mr. Mintz here, but she's not. See
Yes,
if you
Your
can
Honor.
get her assessed with OVP for treatment, and then we'll recall it.
Yes.
And I'd be, if she can get in treatment, I would give her a OR bond.
The Bluffs also might be able to take her.
I'm sorry?
The Bluffs,
Okay. That's another option.
partial.
Okay, well, we're gonna recall you, your lawyer's gonna be looking for a place to take, that'll take you for treatment.
Okay,
And we'll call you back after that's some research.
okay then. Okay.
State of Ohio versus Harry Markham, case number CRA 25283. And Joshua Merrill is on deck.
Harry Markham is that you, sir? You're Harry Markham?
Yes, sir.
Can you hear me okay, Mr. Markham?
Yes, sir.
I'm Donald Capper, the judge at the Lawrence County Municipal Court in Chesapeake, which is where your case is filed. The charge is a theft offense. It's alleged that on January the 14th of 2025, you purposely tried to deprive Jeanette Warner of property being 1,802, there's a decimal point out of the way. Is that supposed to be $1,820 or $18,200?
I think
$1,800.
$1,820, Your Honor.
Okay,
So we'll
so-
make that motion to amend.
I'll move the decimal point. Okay, so the state's alleging that you deprived Jeanette Warner of $1,820. So that's a theft offense. It's a felony because it's more than $1,000. Felony 5. Maximum penalty is a year in jail, $2,500 fine. Do you understand this charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
Well, do you have the money to hire a lawyer?
No, sir.
Do you have a job?
Well, yeah,
What do you do?
I do flooring. I just got back to work about 3 weeks ago.
What do you usually make in a week?
Excuse me?
What do you usually make in a week working?
Just depends on the size of the job that I do.
Well, I have to determine your gross annual income, so you gotta give me, I'm not the greatest at math, so you gotta give me some numbers that I can,
$500-600.
okay, a week? You're making that?
Yes, sir.
Do you have any dependents?
No, sir.
Okay, you said you just went back to,
I just got my vehicle back running about 2-3 weeks ago, and I started back.
okay. Do you have any money saved?
No, sir, not right now. I spent everything to get the vehicle fixed.
All right.
But if I could have it paid off probably in about a month and a half.
I'll appoint Mr. Steyer. Mr. Steyer's going to be your lawyer. He's in the courtroom now.
Okay.
And what's the state's position on bond for Mr. Martin?
We're not opposed to an OR bond, Your Honor.
We would join that recommendation.
Okay, I'm going to let you out on a signature bond of $2,000.
All right.
And I understand you live in Proctorville?
Yes, sir.
Okay. So you sign a piece of paper promising to come to court. If you don't come, you get a warrant, and then you have to pay $2,000.
I'll be there.
When would you like to have your preliminary, Mr. Steyer?
I'm here the 13th and the 16th, and then I'm out until the 27th. I have a jury trial on the 30th, so you have a right to have this heard within 15 days, sir. but if you're out of jail, but that's probably not going to be practical. I would advise you to waive that right, allow us to set this out a little bit further, but it's certainly your decision.
It's whatever you think, sir.
In that case, then I'd like to go out beyond the 15 days, and I don't know when you're looking to set things.
And I have an idea as well, because Mr. Markham said something about he would have the money. We'd be okay with moving it out long enough for him to get out of jail, get the money, and then show up to that hearing with the money.
And that would be fine.
How long do you need to come up, apparently there was some sort of transaction here that was supposed to take place?
We're not going to talk about the potential transaction, sir, but if you were to come up with that money, how long would it take you, do you think?
Probably a month, month and a half at most.
We don't mind waiting a little bit longer, want to come out maybe 6 to 8 weeks and come back, and we'll waive time constraints, which would put us about the end of July, beginning of August.
July 25th?
I actually have a jury trial that day as well, but I'm here the 28th or, well, just the 28th.
July 28th.
In that time frame. And again, we'll waive time constraints to accommodate that, Your Honor.
All right, Mr. Markham, I've set your next hearing. You know where the court is in Chesapeake?
Yes, sir.
You gotta be here July 28th. And, probably Mr. Starr would like to have your phone number.
Yeah, do you have a cell phone?
Yes, 304-690-0803.
I'm going to go ahead and contact you and leave a message. Once you're out of jail, you'll have my number. Get back in touch with me, please.
All right.
Thank you.
Thank you.
July 28th, 10 o'clock is your next hearing, Mr. Markham.
All right, is that on a Monday or a Friday?
That's on a Monday.
That's on Monday.
All right, thank you.
You're welcome.
State of Ohio versus Joshua Merle, case number CRB 17169. Emily Smith is on deck.
Joshua Merle. Joshua Merle, and it's case number 17169. It was a drug paraphernalia charge. It looks like he got picked up on a warrant. And set for a pretrial today. Okay, Mr. Merle, do you admit or deny that you missed your review hearing back in July of 24? July 5th, 2024 is the last you missed a review hearing on this case, and a warrant got issued.
Yeah, I missed it, but while I was in rehab, where I went in I put myself in, and I wanted to get spend more time with my daughter because she's getting to the point where I've been away from so long, and it was getting to the point where I couldn't see her, so I left rehab and was living with my buddy, and just forgot about the whole deal about it.
One on this last Thursday, and it was set for a pretrial today, or maybe Friday.
I'm sorry.
He started being arraigned on the failure of hearing, she said.
Well, it wasn't clear to me, that's why I was making a record on it.
I'm not sure if Mr. Morford was appointed his attorney on this. That's Teresa.
There's nothing marked in there. It looks like you did do a urine screen last Friday, and they had some bad stuff in there.
Yeah, but I'm on probation. They drug tested me, saying I was put on probation.
Your Honor, when I looked at the file, it was not ordered on his judgment entry for him to be on probation. There is no probation, I don't believe there was an entry in there, Your Honor. There was none,
Well, he was, he's missed a review hearing before and got time served then. The judgment entry must just be missing. Is there not one in the computer?
it was not scanned in, Your Honor, that I can find.
Did you ever go home today, Your Honor?
Yeah, there is a way. It's the, my concern is, I'm afraid, I'm afraid for you. You tested positive for fentanyl on Friday.
Your Honor, if I may, I believe he goes to our municipal court this afternoon.
Oh, that's right, we already sent.
And I sent that down, yes, Your Honor.
So you have to appear in front of Judge Waldo this afternoon on a case you got down there, and we let his probation officer know that you tested positive for fentanyl on Friday.
I'm on probation nowhere.
Well, you can argue that to Judge Waldo.
Yeah, me and Walter already established that, last time I was in court. I'm on probation with nobody. I haven't gotten any new charges nowhere.
There was a judgment entry plea and sentence that was scanned, but I can't see it from the courtroom screen. That could be printed out.
Okay, so let's get that.
Okay.
All right, I'm going to recall you. Apparently, we do have a judgment entry, so we'll look it up and get it, and I'll recall you after we get the judgment entry.
But, I couldn't hear you.
I'm going to recall you after we do a little more research. I think we do have a judgment entry on your case.
State of Ohio versus Emily A. Smith, case number CRB 23627. Emily Smith, jail. All right, Ms. Smith is here. You got a warrant issued on May the 9th for leaving treatment. And you were at Southern Hope. So what are we going to do, Emily? I mean, I'm really afraid for you because you've had serious substance use issues. You've gone to treatment several times. We never got them cleared up. And you go for a while and then you take off. So I mean, is this just the life you want to live? Is out on the streets using drugs, or what do you want for yourself?
I want to get better. I realize I need to grow up and do better, and hopefully I can.
Well, do you want to go back to treatment?
Yes, I do. I've been in contact with Southern Hope, but I'm not sure what they have planned or if you all have a different plan for me.
Well, Mr. Quan is here today from Southern Hope. I don't know if they would take you or not because you left against advice previously.
Several times. I think everybody deserves another opportunity. Who knows when this time will be that time.
Okay, sounds like they're willing to take you back.
I would appreciate it so much.
Okay, because that's better. I think at one time you were living on the street, weren't you? That was what I was told.
I've been living on the streets for a while. I'm tired of it.
I'm afraid for you to live on the street. Afraid of what could happen to you. So, all right, Mr. Quans and him or somebody from Southern Hope will pick you up. At least you'll have a place over, a roof over your head and food, and they won't let you take any drugs. So,
yeah.
Let's get clean and stay clean this time. How old are you now, Emily?
25.
Okay. They used to be a full-grown adult. It's kind of like a teenager now.
Feels like I'm a kid still, for real.
In the 1970s, 25 was, a full-grown adult. In the 1940s, when my parents were alive, my dad, by the time he was 22, had been in the Army to Iwo Jima and back and was working a job by the time he was 22. Now we got 22, you're still in the basement playing video games. So it's time to grow up. You got a good chance here. I want to see you be successful. I don't mean to make light of it, but take advantage of this, get clean and stay clean. I know your family wants you to get clean because I hear from them periodically, and they're afraid for you too. So I'll release you to Southern Hope for treatment again, and let's see you in 2 or 3 weeks and see how you're doing.
Thank you so much.
So let's make it to the 23rd. That's 2 weeks. June 23rd will be your next hearing.
Okay, I have the enrollment out, gentlemen.
Thank you, Your Honor.
2000 OR.
Is Mr. Stratton still virtual?
He is. You're welcome. Good luck. You can do this because you've done it before, and
for stretches of time, then you always go off the ranch. So don't stay on the ranch and get it down what you need to do this time.
Thank you, I appreciate it.
It looks like there was one.
Well, it wasn't the original.
It looked like the original was.
Maybe it was like you were.
This, I was going to leave these guys.
Yes, Your Honor, we have several more to recall to jail, but we're not ready for those yet.
Okay, we'll go back to the jail later. Looks like it's gonna be an all-dayer. Looks like.
State of Ohio recalls Mackenzie T. Webb, case number CRB 25340. And Caitlin Kelly, case number CRB 25336.
Okay. I won't require, not a sterling result, but one I guess we can live with without requiring to get a treatment. Anything else either one of you want to say before I send you?
I want to admit my faults and know that I'm at wrong. Regardless of, I could sit here and tell you that it was my baby's formula. I just had a baby 3 weeks ago, so I was trying to get her food and stuff, but regardless, I've now realized that there's other ways to do things and there's other ways to go about it, and I have 2 kids at home that need me more than I need to think about myself in that position, so going forward, I don't ever want to put myself in something like that again.
It's a bad decision. We all make some bad decisions at times. Just learn from it. I think your children would, down the road at some point, would rather have a parent that didn't have a criminal record than one.
Right.
No,
absolutely.
You talk about the adverse childhood experiences, because you're not going to go to jail.
And then it's stuff like this that affects my job. Like I work for NETCO, doing
So
a
you
direct
see
support
people
professional.
dealing with
Yeah, every day. So, yeah.
Okay. All right.
This is just a huge eye-opener, and it's just not somewhere that I want to put myself again after this.
Okay.
I definitely made a mistake.
All right, for each of you, then I'll impose a $100 fine, court costs. 10 days in jail, all suspended on the condition that you do 5 days community service. Your review hearing will be December 8th. So you shouldn't have to worry about it. So you just get everything done before December 8th. You don't have to be, that's a check to make sure you did what you were to do.
Okay, so just make sure we did this done before, okay.
If you get it done, you don't have to come back.
Okay.
If you don't get it done and you don't come back, that's the way you go to jail. You get a warrant. Everybody that doesn't show up and has stuff left to do gets a warrant.
Okay.
Here's the biggie. You gotta stay out of Walmart.
Yeah.
Your order to stay out of Walmart. And I think that's everything on your judgment entries. You'll go check in with the probation officer, Mr. Major. He's to the left as you leave the courtroom, his office. Go talk to him. Get this done. Go on, have a good life. Don't have any more screw-ups, and you'll be fine.
Great. Thank you, Your Honor.
Thank you, Your Honor.
December the 8th is your review,
Okay.
if you
Thank
need
you.
it.
State of Ohio versus John C. Henry here at the court, case number CRB 25139.
Okay, so this was actually set for Friday for pretrial, and you were incarcerated in West Virginia then? Is that
Yes,
what happened?
sir.
Okay, you got something showing that? You just stay there, somebody will come. Mr. Hall, can you go get the document from the defendant? you. Is this my copy to keep, or you?
Yeah.
Okay,
Yeah.
thank you. Okay, it's a good report. And was there a reason it couldn't be here Friday?
Yes, I got picked up on a,
Oh, that's right.
oh, warrant, yes, sir.
That's a legally sufficient reason to not be in court, is that you were incarcerated someplace else. So
Yes.
it's not the greatest reason in the world, but it's sufficient. So, Mr. Stratton is still representing you. He's usually here. He's not here today. So I'm going to continue it. Let's make it the 20th. I think we'll be here then.
Yes.
June 20th at 10 o'clock.
All right. Thank you.
You're welcome.
State of Ohio versus Gage Townsend, case number CRB 25204. Gage Townsend.
This is actually an arraignment, it looks like. Gage Townsend, domestic violence. I have no proof of service, so I'll pass it. There's no proof of service.
Erica Townsend?
Gage Townsend.
It's passed, Mr. Jones. No proof of service.
You must have checked in the form, Your Honor.
No, he's not important.
Can I have that file that we need to check that into?
Yes.
And then touch it with
Here they came in to take care of it.
State of Ohio versus Alexis H. McDonald, case number CRB 25280, CRB 25161. Mr. Holt's case.
This is Mr. Holt's case set for pretrial.
Your Honor, I believe we're probably just going to set this for trial.
On both matters.
Yes.
Yeah, that's fine with us.
All right, well, these are, we've got an M3 and an M4. What's our time situation?
We have waived, there was a subsequent, the M3 came after the M4, so I think that would supersede on the time. And we had previously entered a temporary or specific time waiver.
So we probably would need an agreement to a time waiver to the trial. I don't know whether that happens automatically because it's being set for a trial, but.
Not according to the Court of Appeals.
But we also, Your Honor, we know of a couple dates.
We're fine
that
with it.
The victims can't be here. They've already told us.
So there's two different sets of victims. And in this case, which is.
Let me go grab, Your Honor, can I go grab my phone?
Sure.
14th through the 20th. Okay. Right. Is that the only ones?
The other victim's here too, and she's did the same thing about going on vacation.
So the 14th through the 20th of July, we just to be able to avoid that.
Oh, okay, so that gives us plenty of time before then.
Would the 7th work, Your Honor, of July?
July 7th?
Or
No, because we're still bound. June 14th.
Yes.
Oh, it's June, I'm sorry, it's
Oh,
June 14th through July 20th. So that really
and
changes things a lot.
That's
Yeah, it's a long time.
They're retired and apparently they've already.
Big trip.
It has, my client would prefer to be on a Monday for work purposes. 21st?
Of July?
That's the very first available.
And if it has to be sooner, I guess I could pick up
His witnesses.
Probably watching
can't be there. Or she could take a personal day if we want to do it before, but that's the very first day that you could do, from what you said.
It's 1 more week after that, like the 28th or something, if that's okay with the court.
I have a hearing at 1 o'clock in Ironton that day.
That ain't gonna work then.
I'm fine with what he's saying. The 28th I couldn't do.
First available day in August.
I could do the first Monday in August, Your Honor.
That's the 4th
Yes.
at noon.
Yes, Your Honor.
Okay. Both cases are set August 4th for trial at noon.
I need to meet before then, okay? Okay. So call the office.
State of Ohio versus Robert Clark, case number TRC 25896, DNC.
Good afternoon, Your Honor.
Good afternoon. Mr. McCown's case at the pre-trial.
Thank you, Your Honor. Your Honor, I have been provided discovery from the state. I've gone through that, and I have pointed out to Mr. Hill some issues, I think, with the investigation. He's wanted an opportunity to review those on the from the video. So I would ask him, we will, of course, waive time for that time period, this to be reset for June 27th, so that I can direct his attention to these specific issues.
What was that date?
Yes, Your Honor.
All right, June 27th will be the next pre-trial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Mark Daniels, case number TRC 241469, A, B, and C, and TRC 192674.
All right, Mr. Steyer and Mr. Morford.
I think the 19...
He's already been sentenced on the 192674.
Right, I believe those cases are post-conviction, and I've been appointed to cover him on those, but either way is fine. I'm here on 24-1469, which we discussed in chambers earlier. I believe the state may have a motion.
Your Honor, this is the matter that we received the email correspondence from the trooper, and he indicated that he felt, given everything that he was able to gather in this investigation, that the evidence was insufficient to support an OVI conviction. So I think we're left with needing to dismiss that charge.
All right, so that we acknowledge, but we still have the 192674. From what I can tell, Mr. Daniels never did anything he was ordered to do on that, which ordered him for treatment, alcohol counseling.
I did all that, sir.
Community service. I have no proof of it.
The problem that might arise, Your Honor, is that the treatment was ordered was with Spectrum, which no longer exists. Now, the question of whether the payments were made and the community service was done is something we can look to the court's files for. But the issue of the community, of the issue
You're
of
not
the
on this
treatment.
case, Mr. Steyer.
I'm sorry?
You're not on this case.
Oh, okay, I thought that was on both, I apologize.
You're not.
Step
And
aside.
he failed to appear very early on. So he's been out, he's been on over 5 years since he's appeared.
Take care of mine.
There's not one document in the file saying that he went to treatment or did any community service or paid anything on his fines or costs or even nothing.
My client would admit that's the situation, Judge.
Okay. Like Ms. Smith said before, and I know Mr. Daniels pretty well from over the years, although he hasn't been here for a while, I think he's got a serious alcohol problem. So I want him to get assessed and treated. Do you have a medical card?
Yes,
Okay. And you live in Scotttown? Where do you live?
Linville.
Where?
Linville?
Linville, okay. That's like a suburb of Scotttown.
Yeah.
Well, would you rather go to Chesapeake or Ironton to get your treatment?
Ironton.
Ironton?
Yep.
I thought Linville was more connected to Chesapeake. But anyway, who in Ironton would like to assess and give Mr. Daniels treatment, and it's alcohol. We've got multiple alcohol-related offenses. All right, so we got you a place lined up. So I want you to go, we've got someone for you to talk to and come back in 2 weeks.
Sorry, Your Honor, I was
Hometown, right? Hometown? Recovery. At 9 o'clock. That's going to be the main thing, is get your alcohol issues under control. You still owe some fines and costs and community service. I'm not as worried about that. You still have to do it, but let's get the alcohol under control.
Right.
While you're still on the plan.
Yeah,
Keep
I'm
drinking.
barely here now.
Okay.
Thank you.
State of Ohio versus Elson Childers. Case number TRC 25107, A, B, and C, and TRC 23629, A, B, and C. Your Honor, this is actually Ohio Smith's case, but I understand that Mr. Wilford is stepping in.
Okay, Mr. Childers was supposed to be here Friday. I think he came late, right?
I was here, I was just out in the lobby, and didn't hear my name called.
So you weren't in the courtroom when you were called. I remember you came in late, Mr. Lawyer already left, wasn't he? Did he see you on Friday? No? Okay. Well, we're just gonna have to continue it, and Mr. Smith gave me some dates when he was available. He's in Wayne today. So let me find his text. I remember going to a hearing out there once when Judge Chafin was the judge. My case was set for 9 o'clock, and I sat there all day, wound up going, it was a Wayne restaurant across the street, went there for lunch, came back. It was 3 o'clock before the judge ever heard my case. So this is kind of one of those days. And he didn't do it on purpose. I mean, they just had a lot of cases. Well, he's available Friday, and that's actually one of the lighter days coming up. So let's just continue it to Friday. Will you be here then?
I work Wednesday through Sunday, and I'm off Monday and Tuesdays.
Where do you work?
The boat dock at Beach Fork State Park.
Okay. June 23rd then. That's a Monday.
Thank you, sir.
June 23rd is your next hearing. And I'll let Mr. Smith know right now.
Thank you, Judge.
You're welcome.
Yes.
Thank you, sir.
Just be here on time and in the courtroom.
Yeah, make sure you track him down and talk to him before your case gets called. Oh, okay. It's your bedroom, Rick.
State of Ohio versus Krista Briggs, CRA 16161. Her attorney is here.
Mr. Matthews.
Good afternoon, Your Honor.
Good afternoon. This is on an expungement.
That's correct, Your Honor.
Any opposition to it from the state?
No, Your Honor.
You have an entry or?
We filed an entry along with the motion, Your Honor.
Okay, you did. Okay, we'll let Mr. You'll look it over. If he approves it, then I'll approve it.
Thank you.
Okay, your entry is approved. Do you want to take it and give it to the clerk and have it filed?
That'd be great, Your Honor. Thank you.
Okay, you can approach and take the file and the entry, get it filed with the clerk. Okay.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Robert Turley, case number TRD 25909. This is actually
All right, Mr. Smith notified the court this morning he had a jury trial or something going on. He couldn't be here today, so Mr. Morford standing in is set for a pre-trial. This is the first. Well, it actually says arraignment, so I don't know, has he been arraigned yet on this?
No, sir.
Okay,
Computer is a pretrial, Your Honor.
well, but I don't think, it says arraignment date is June 9th. So, have you been here before, sir? or-
Yes, sir. You told me to come back here because where I was without insurance and I got pulled over for, I can't remember what it was. Oh, what?
And you hired Mr. Smith to represent you?
Well, yes, sir.
Okay. All right, well, he can't be here today, so we'll just have to continue it to another date unless you got some other proposal.
Judge, he's presented me with documents showing that he's got insurance and his license reinstated.
Okay. He had insurance at the time this happened, but it says yes, box check on insurance.
Your Honor, it looks like he was set for traffic court on May the 13th.
Yes, it was cited in the traffic court, which was wrong. He should have been in this court because it is a jailable driving under suspension. I don't know how it got transferred over. There's no notations on here other than pretrial today. There's no report either, no explanation of the circumstances of the citation or anything, so what's the state want to do with it?
What's the charge, Your Honor? I had
Driving under suspension.
All right, well, he's got a document there that looks like it's authentic, and it says that he's valid as of May 27th. So if that was the goal, was to make sure he got valid, then he's done that. And it looks like he has insurance currently now, but you're saying that he had insurance at that time too.
He did.
This is the first time, I don't know what the basis of the suspension was even.
Well, the only thing that, and the officer didn't write any kind of report, because usually they'll write some reports to why they stopped them, probable cause, nothing. They attached the printout, and there was a child support suspension, which was closed. The only one that was still open looked like it was from this court. Yeah, it was case number, we can look it up, see if it was taken care of, 2317. 2317 was from this court. That was the open suspension.
2317.
710. 710.
Okay, that he had a final payment plan on. Signed their way.
So it is closed.
May have been a suspension for no proof of insurance.
Okay.
It was sent on this ticket, there's no proof of insurance. Yes, because the ticket has been paid.
All right, be dismissed.
All right. All right, thank you, sir.
You're welcome. Thank you, Judge.
State of Ohio versus Melissa LeGrand, case number CRB 24462, CRA 24513.
This is Mr. Morford's case.
Judge, we're looking for a report from hometown.
She was here, is she did the assessment.
I was just going to say, I thought she...
Somebody in jail, I think. Fine.
Graham? Yes, you have a report. Okay, it looks like there was some issue on a recent urinalysis, so they're doing some further monitoring.
Yes, Your Honor. She had the drug screen that you see in there, and she was put on restriction. She's doing well since then.
Okay. Mr. Morton?
I believe that alcohol was contained in the medication she took. I think she needs to continue, Judge.
Okay, so you're agreeable to continuing and get hopefully a cleaner report next time? So let's go to July. July 11th.
That's good, Your Honor.
Okay, next hearing for Ms. LeGrand will be July 11th. Continue with your counseling.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
State of Ohio versus Carl E. Cooley, the second, December CRD 23325, 1474.
Carl Tooley. Mr. Morford's case. Set for today, Carl Tooley, been called for.
She said he was here now. Get out in the car, that's what they told me.
He's not here now, pass it to the end, we'll recall it at the very end.
State of Ohio versus Gage Townsend, case number CRD 25204.
Okay, this was set for arraignment today. And one of you is Gage Townsend?
Yes, sir.
Same, and who are you now?
I'm the one who made the statement.
You're Erica?
Yeah.
Okay. Have you received a copy of your charge?
No, sir.
All right, you've been charged with domestic violence, a fourth-degree misdemeanor, and you're being served a copy of the charge now. It alleges that on March 27th, so this has been some time ago, 2025, in Perry Township, you knowingly, by threat of force, caused Erica Townsend to believe you would cause imminent physical harm to her or a member of her family or household. That's a fourth-degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. You understand the charge?
Yes, sir.
And were you here when I explained rights before?
Yes, sir.
Any questions about your rights?
No, sir.
How do you plead?
I don't, not guilty. I don't.
You want a lawyer appointed?
Sure.
Do you have a job?
Yes, sir.
What do you do?
Roofing. I own my own company.
You said you own a company or you work for somebody?
I own the company.
Okay. Do you file an income tax return?
Yes, sir.
What do you show you? I have to determine your gross annual income because not everybody gets a free lawyer. Depends on what your income is.
Last year I made about 100.
Okay, and I can't appoint a lawyer for you.
No, that's fine. Our goal was to, I don't know how this works, but get everything dropped.
Well, you need to talk to the prosecutor. He's the one that filed the charges. I don't file the charges.
Okay.
So ma'am, you go talk to him.
Okay.
We'll
and see what he has to say.
She's written a statement for us.
Okay.
Now, it's an M4 domestic violence, even though think the threats, if they really happen, are pretty serious. And it shouldn't be just brushed off. This happened back on March the 27th. So there's been some passage of time, and apparently there haven't been any problems that have come to the attention of anybody in authority. So that's a good thing, but we want to make sure that there really aren't any more problems that are going to continue. So we're never, very rarely are we willing to just dismiss the case right off the bat.
Yeah.
We'd like to make sure that there aren't any ongoing problems.
Yeah.
I know if somebody said those things to me, I'd take it seriously, put a bullet in your head. I mean, who would say that, you know? You got to treat each other better. We'd like for you all to do maybe some marriage counseling.
We have been, and she also put on there that she was under some medication.
I should
And
not have made those accusations and said that it escalated to that point.
But you're in counseling already?
Yes, I'm doing it by myself for my own mental health, and then we're doing it as a couple as well.
So we'd like to see that continue. That's great. That's good to hear.
Okay, so I'll enter a not guilty plea for you, Mr. Townsend. You're welcome to our lawyer at any time you want to. I'm going to let the case pen for a while. You want to, I can set it for a trial, and you have a right, because this is a lesser offense. It's the time frame for coming to trial is shorter. So if you want a trial, you can set it pretty quick. If you want to try the counseling and see if that resolves things that way, then you're agreeing that the time constraints don't apply. Do you understand that?
yeah,
How do you want to proceed? Do you want to set for trial, or do you want to?
we've been back together for a while, and everything's been perfectly fine. So
If they completed the counseling,
we've been going to counseling probably 2 months at least by now.
Yeah.
we'd be willing to dismiss the charges at that time. We just want to make sure that everything's okay.
Our counselors told us that we've pretty much wrapped everything up with what we can do with them already. But
Okay, sir, you're not listening to what I'm saying. If you want to set for trial, I'll set it for trial, and it's going to happen pretty quick, within a few weeks. If you want to continue counseling, you said that you're finished with counseling.
we can just do the
then-
trial, it's fine.
Okay, I'll set it for trial. And these allegations, and I don't know if the allegations of the affidavit are true, but they're serious.
I know.
I mean, it's serious language. It's not, I pushed you, somebody pushed me, or somebody slapped me on the wrist. These are serious allegations. I'll set it for trial June 30th at noon.
Okay.
12 p.m., June 30th for trial.
Is this something that has to go to trial, or is it something that we could continue counseling, or?
Well, that was the offer, and he said he didn't want to do that. He wanted to
Oh,
have a
he didn't understand.
I don't really,
Can we
I've never been
continue
through anything
counseling?
like this, so couldn't tell you what, I mean, I haven't sat down and talked with anybody on.
What we'd like to see is that when you come back the next time, that you have something that shows what counseling you've been in or what counseling you're in.
That's
And we
fine.
can make a determination at that time whether it needed to go further or whether you've done enough.
That's okay. Yeah.
Is that okay, Judge?
Sorry, I've never
Okay,
been
so
through this, so.
we'll set it for about a month out, but I want to see, you know, I don't want to be responsible. I mean, people get hurt all the time in domestic situations. And I'm looking at this affidavit. If something happens to you, ma'am, your family's probably going to be mad at me because I didn't intervene. I mean, look at the affidavit, what you signed when this happened. That's serious, serious allegations. If that really happened, I need to intervene here,
Yeah, I understand.
okay?
Yeah.
This is not acceptable. If he said the things that you said in that affidavit, that is no way acceptable or excusable.
So on our last statement, it was stated that I didn't do those things, so. She was she just started medication that she never started.
That's what you're saying. I haven't heard her say that.
Yeah. I'm on a new medication, and actually, that's why I'm doing my own counseling myself. Getting that.
Well, bring me back some proof of that.
Okay.
let's keep that date and we'll change it to a pretrial and bring me some information from your counsel, and you'll have to agree that you're waiving confidentiality so I can see it. Because I don't want to be responsible for you getting hurt or killed.
Okay.
And I didn't intervene in any way. You said, okay, yeah, probably nothing happened. Go on your way.
Yeah.
No, I'm not doing that. June 30th at 10 o'clock is your next hearing.
And we'll need to have a time limit to you on which I've prepared.
Bring your reports from your counseling. No problem. Thank you.
I need you to sign something here, sir.
Yeah.
Yeah.
Mr. Townsend.
State of Ohio versus Tracy D. Dillon, case number CRA 24575, CRB 24576, CRC 24882.
Sign that right there.
This is Mr. Steyer's case, it's set for pre-trial.
May I approach, Your Honor? Is this a copy that you
You can have it. You can have it.
Phil, go up for a moment, please.
You know she's supposed to have a follow-up on May 23rd. I don't. You seen this? Attorney on that? Warford initial. She has papers. Yes, she was sentenced. She was sentenced. Stamped it, that must have been May 31st, 24. Yeah. Not on this one, this was attached to it.
Said you were supposed to go to Press there on May 23rd. Are you still with Press there?
Yeah.
Okay.
My appointment is 27th of this month.
I'd like to see something.
No, it won't pay for the whole thing. Okay. The medical card will not pay for it all. Can you pay for the rest? Okay. Your Honor, she is indicating that she believes she can get the DIP school done next month. I don't know, have you signed up for it yet?
No, I just called them,
Who did you call? Did you call
Ohio, Portsmouth.
Portsmouth? I don't know who does it in Portsmouth then. Is anyone here from Lawrence County? There is a local one. I don't know when they're next. They don't do it every single month
I
though.
think it's not till the end of July, so whatever.
Can I get the number?
Yeah, but it's outside. I'll have to come out and step out and give it to you in a few minutes, in a couple minutes.
I think it's Lawrence County Recovery. She needs to get a hold of this, that does the classes.
Yeah, Lawrence County Recovery does the classes here. There probably is somebody in Portsmouth that does it, but I don't know who that is.
There is one.
Okay,
And I think we have the information, Mr. Major, though.
that's what I was thinking. I think, Your Honor, if we could, maybe we could come back. She's got to get that DIP school done, which I think is the main holdup on the older case. If we could come back on does Monday or Friday matter to you?
Monday, good.
If we come back on the 14th, I'm going to speak to her about what we might need to see. And even if we don't have the DIP school done by then, we might have paperwork showing that it's set up.
14th of July.
14th of July, yes, Your Honor.
All right, July 14 will be the next hearing at Trinity.
Don't leave. I need to talk to you. I may have other cases calling me. It won't be long. Okay, just wait for me in the lobby if you don't mind.
July 14.
Thank you. Just wait in the lobby. Oh, this guy right here does that. But still, please wait for me.
State of Ohio versus Douglas Curd, case number CRB 25115.
Your Honor, Mr. Kerr has retained me since the last hearing. I believe that Friday actually is.
Set for pretrial today.
I believe we have an agreement on a potential resolution in this matter. My client would agree to waive time on a 90-day continuance and pay court costs if there's no further issues in the dismissal.
We've been speaking about this for a while. He's a veteran, and we had discussed the idea of him going to the VA for treatment. But he wasn't able to go before because he didn't have transportation, maybe.
Mr. Kerr he just recently got his 100% disability from the VA, so he does get treatment from the VA. I believe there were some substances found, but those were not belonging to the defendant. It was the alleged victim who I believe at one point did have the charge, but she's incarcerated now on a drug charge.
Yes.
Here.
In Lawrence County. I don't know if it's through this court or not.
Tara Curd, certainly.
We just have a,
Okay.
So we want Mr. Curd, we want to make sure he's doing all right, and we want him to go to the VA. And I don't know if he's resistant to that or just really hasn't been able to get there.
He is in the VA system. It's just, the substances were not his. I think it's the subsequent actions have proven that.
But this is
position on that.
This is a domestic violence charge.
Correct.
So we believe maybe there's some need for some kind of treatment there, whether it's mental health or.
He's 100% disabled. He's a Gulf War veteran, served in combat.
Well,
So he was already doing that before.
Okay, well, look, what I'd like to do then is get a report about how he's doing, if he goes there regularly and that kind of thing.
I didn't understand that was part of it.
Thank you, Mr. Ashford.
Is he willing to do that?
I don't think there's, circumstances, I don't think it's necessary. I didn't understand the discussions that went on either.
What are you proposing to do?
We agreed to a 90-day continuous for the problem dismissal clause.
Approach, Your Honor.
Yes.
And Your Honor, if she's just recently been here, if you could look on your records here to see what her status is here.
Tara Kerr. C-U-R-D, Tara, T-A-R-A.
I believe an ankle monitor.
She's on treatment from this court at Bethesda.
She was.
Tara Kerr, is she at Bethesda? Oh, she's in the jail now.
I think part of the bond was a GPS monitor, but she doesn't have that.
No, she has, she's waiting on check.
She's waiting on one.
Yes.
All right, so what we would suggest, I don't know what the living arrangements are now, if Tara Kerr goes through treatment and gets out, whether she'd be coming back in that household
She
or
does
not.
not live with him now. She didn't live there when this happened. She came to the house with the child, and he kept the child. The child's still with him, the grandson.
All right, so
Granddaughter.
what we would agree to then is to do a 90-day continuance. And at that time, and if something happens with Terra Curb that would maybe cause us to feel like there needs to be some sort of a review, maybe we'd ask to come back sooner. But at the 90 days, we'll look at it and make sure everything's okay.
It's fine, Your Honor.
Okay, so that's September. Sometime around September 9th, what's your availability?
We could, do the 8th work, Your Honor?
Yes. September 8th. Be the next hearing, pre-trial.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Raymond Harold McKinney, case number CRA 25326. Your Honor, he has been picked up.
All right, this was a warrant out of North Carolina. He waived extradition, and he was picked up by North Carolina.
State of Ohio versus Shelby M. Person Jr., case number CRB 2579. Shelby M. Person Jr.
Okay, my notes on this, I was going to dismiss it if there was no problems reported and no appearance by the defendant was necessary. So, hearing no problems, case will be dismissed.
State of Ohio versus Timothy Ryan White, case number CRB 25222.
All right, this is a pre-trial. Mr. White said he would be hiring counsel. Have you hired counsel, Mr. White?
No, whenever I was here, I'd ask you if something happened, if he doesn't show up, if it would just be dismissed. So I'm not going to hire counsel until I figure out if he shows up. Because I've spoken with Tyler, or Gary Roberts, whatever, and we've resolved everything, so it's,
What about Amanda?
I don't even know her. I've never,
We'll try to get them here for another hearing.
I should say, I don't know her, never met her in my life. And if it's over the phone call, that day they called me, they blocked their number and called me from a blocked phone number. They didn't identify themselves, so how was I to even know who I was talking to? So, I mean, if there's any way we could get this resolved today, I would love to, because it's so hard for me to get off work. I mean,
Okay, can you get in touch with somebody on the complaining side?
Well, we can try to do it now.
Yeah.
Okay.
Okay, we'll recall them. We'll let them try to get in touch.
You
with
want,
them, see what they say.
would you like for me to try to call Tyler?
No.
Okay. Or it's Gary.
Okay.
I don't know about Tyler, I'm sorry.
If you've got his number, maybe we can make sure we've got the right number.
I can give you, and Judge, this was,
Oh, okay, yes, we need that. John, did you get the fingerprint card?
is this all you needed, sir?
Yes.
Okay, so you've talked to
I don't know if that's the right one. We've got a fingerprint card.
You want?
Let me look at it.
That's the one.
No. Yeah, that's not the right one, but you went down and did it, it was the sheriff's fault.
That's not the right one.
It's not, but we'll live with it.
Okay.
Your Honor, we have spoken with Gary, and so we know how to get a hold of them, and they're still serious about the case.
Just set it for trial then.
I was literally just with him Friday night. Friday.
We can
I
call him.
was just with him.
We'll call him again.
We'll try one more time.
I started saying I was with him for an hour on Friday.
Or just have a seat, we'll have them recall.
State of Ohio versus Robert D. Fox, case number CRA 25100.
Mr. Delauder's case set for preliminary hearing.
Your Honor, this is one we were here for originally on May 5th, and continued it to today to allow Mr. Fox to reestablish care with Bethesda and hopefully make progress. We intended on seeing if he qualified for QRT, but after speaking with him this morning, he does not qualify. So I think Mr. Hill's desire at this point is to keep it here for a little while to see if Mr. Fox continues to be compliant with treatment.
Yeah, the report.
Mayor,
Yes. Okay, it's a very good report.
And then whenever you want to come back.
Approximately a month, what's your availability in July?
You said a couple on the 14th, is that okay?
Yes. July 14 will be Mr. Fox's next hearing, 10 o'clock. Preliminary hearing.
Thank you, Your Honor.
Thank you.
You're welcome.
Okay.
State of Ohio versus Casey Lynn Blevins, case number CRB 24488 A and B, CRA 24487. Your Honor, this is one of this case. I'm not sure. Mr. Morford here.
Yes. This is Roger Smith's case. The last report I had from ODP was in the end of April. This was when her last hearing was. Do you have a report today?
Oh, sorry.
Go ahead.
I wasn't aware I needed to bring one. No, I don't.
Okay, state's position.
We'd certainly want to have one next time.
ODP, yeah.
You still going?
Yes.
Yeah, there is a felony pending here.
I'm just used to Bree bringing it. I didn't.
Yeah, usually she's here, but she's not today, so. Did Mr. Smith give you any dates, Mr. Morgan?
I've got some, yes, Judge.
Okay. A month out?
7/7 or 7/14, 7/18.
7/7. Next hearing, July 7th, 10 o'clock.
State of Ohio versus Gary L. Calico, case number TRC 25-46 A and B.
Dyer's case, set for pre-trial.
Your Honor, when we were last here, this is one that the state had looked at possibility of a reduction, but wanted to see an assessment. I talked to Ms. Dempsey from Minute Reads. She has emailed me and Mr. Major the assessment. I guess probably forward this to you and Mr. Heald. But the assessment, which I've just forwarded, does state that he went in for an assessment. He explained to them he was court ordered, that this was in relation to an OBI, that there was an OBI in his past, and explained the situation, and based on the description and the interview, they said they do not believe that services are necessary.
Well, if he's convicted, it's required. But is there a dismissal here, or what? It was a 081?
Right, this is one where, and if I may, in addition to being 081, on the test, if you look, the difference between the two tests and the blank, there's a larger percentage difference than that. So we had discussed the possibility of a reduction to a reckless operation, but we wanted to have an assessment before that was accomplished.
Because of the fact that it was a second, I felt that it was important for him to be assessed anyway. And it is very close, and there is, I guess, a slight discrepancy in the testing. So I think we could agree to do the reckless operation. We'd want him to do the dip school vote.
And what's that?
They want you to do the 3-day school.
All right.
Okay, he's willing to do that. We had discussed that before. We would have already worked on getting that done. That's a new wrinkle to the case.
Okay, well, my understanding is that's not going to be offered until July
The one
here in Lawrence County.
The one here in Lawrence County, we could potentially, Mr. Calicote could go further afield and get one done sooner. There's the least expensive that I know of is in, not Portsmouth, Chillicothe. It's significantly cheaper, but also you got to get yourself a Chillicothe, so that can be an impediment to some people. We've been giving him a continuously extended driving privilege. I would ask, I don't know if there's a copy of the order in there. I don't know if it obviously doesn't mention the dip school because we didn't ask to do that. I would ask that if we do this, we extend the limited driver privileges to cover the dip school.
Okay. Yeah, the entry's in here and expires today, so if you want to draw.
Yeah, I'll need to do a new one.
We can make it, I think that the one locally is not over until around the 1st of August.
And my concern is that, I mean, just because that's the next time they have one doesn't mean that there's availability for that one. They're not doing it monthly, so it may be full. But I think coming back, maybe August 8th if we could, Your Honor, we would at least know where things are going. Don't believe I'll come talk to you.
August the 8th. Okay, draw up a new entry on his driving privileges. Next pretrial is August the 8th.
Yeah, don't believe I should be driving entry. Thank you.
Thank you.
You are.
State of Ohio versus William Kaplan, case number CRA 24631, CRB 111152. William Kaplan.
Looks like I was right.
He was here earlier.
He was?
Your Honor, I swear.
William Kaplan.
I hadn't looked for him in a while, but he has been here.
Okay. My prediction. Kaplinger. Okay.
I apologize, Your Honor.
Be a warrant issued for failure to appear. And I don't, yeah, it looks like it was an OR bond. I don't think he has a.
He's got a bond through Mr. Sowers.
He does?
Yes, Your Honor.
Okay. He does, from last year. Mr. Sowers probably roots the day that he wrote this one, because I think he's had to get after him a few times. Okay. I will issue a warrant today for failure to appear, and I'll notify Mr. Sowers of that fact, and set a bond forfeiture hearing June 30th. should be held without bond. He does get arrested.
Did you say the 21st?
30th,
30th.
bond forfeiture.
State of Ohio versus Trent Austin Coburn, case number CRA 25275, CRB 25277.
Your Honor, Mr. Coburn has retained me, but he was here before prior to retaining me. You ordered that he go to the Sheriff's Office for fingerprinting. I have that. May I approach?
Yes.
Again, I think the biggest thing there's actually some fingerprinting they were supposed to do, but it's basically what they did.
So we need to have a conversation with the sheriff's office, I guess. This has happened 3 or 4 times. So I don't know what, did you give him the document we sent? All right, it's not your fault.
The Common Pleas Court has a form document that they use that seems to get the right fingerprinting done. You might want to talk to them about trying to get a copy of that and adapt it. There may be language there that's what's getting the.
Well, we changed our bond form, and it says on, if somebody's coming in with a criminal bond form, why they would give somebody a civilian fingerprint,
Well,
I don't know.
Right. I just know that this Common Pleas Court's been sent a certain file or a certain order over there for years and seems to work. Maybe it's not working either. I don't know. Maybe they're doing the wrong fingerprints on them too. We just don't know about it. Your Honor, the state is offering to have Mr. Coburn looked at for the QRT program. We would need to get him started in treatment as well as an interview with Ms. Dalrymple. I'm not sure if Ms. Dalrymple's even still here at this point.
Is she here today?
She was earlier, but I don't know if she is now. So I think it would be worthwhile to continue this one briefly.
Does Monday or Friday matter to you? No, I won't be off the boat again until the 10th of July.
Okay. So Mr. Coburn, hold on, that's a
I think it's like a month on. She's gone, Judge.
Let's continue. Let me look at it closely.
We're going to, I think there may be a wrinkle with the possibility of QRT, but we'd like to continue this matter. We will waive time constraints to accomplish that. Mr. Coburn, he works on, is it barges, I guess? He works on barges, so he's gone for pretty long stretches. He will be back here for the 14th of July. I think he comes back, you said July 10th is when you're back. So if we could set this for July 14th, I think we may be able to get some traction by that point.
State agrees.
Yes, Your Honor.
July 14th will be the next hearing, 10 o'clock.
Well, 10 o'clock. Thanks. Thank you.
State of Ohio versus Glenn Gibson Jr., case number CRB 10-1078 A and B, CRC 10-2432 A, B, and C.
This is on the sentencing docket, where Mr. Gibson is making payments on his, community service, fines are paid, so it's community service. You got any community service to turn in, Mr. Gibson?
Yeah, I was just here this past Saturday.
Okay.
They've been keeping track of it.
All right, well, that's not in file yet, so. All right, we'll reschedule it. We'll a month out. July 11th for sentencing.
All right, thank you.
You're welcome.
Starting to have some recalls. State of Ohio versus Carl A. Poole II, case number CRB 23325, TRD 051474.
He still hasn't shown up, I don't think.
I've not seen him, Judge. I went out and looked for him.
The
Blank entries on here. There it is.
bench warrant.
I found it.
I think there's a bond on that. Yeah, it looks like he had an OR bond, so it'd be a bench warrant issued for failure.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Timothy Ryan White, case number CRB 25222.
Is the state able to get a hold of anyone?
No, all we can do is leave a voicemail. But we'll make sure before we come back again that we talk to them and we'll get their opinion about what they want to do. May want to come back fairly quickly.
All right, so Mr. White, I'll let you have some input on that. What's better for you, Mondays or Fridays? And
Typically Mondays, but whatever day, if you've got a light day, something that's not like today.
I'd like to have a light day. When the weather gets warm,
Yeah.
so does the criminal life. People get out, stir around.
I had no idea I'd be down here this
stuff
long.
They're not supposed to do, and they wind up getting charges.
I had no idea I'd be here this long today.
That's the way it goes. As of now, the 23rd is not too bad, by the time we get there.
You never know. Is that June 23rd?
2 weeks from today.
Okay.
All right, I'll set it for June 23rd, 10 o'clock.
Thank you.
You're welcome.
State of Ohio versus Craig Lowe, case number CRB 25310.
Mr. Delaire's case, this is the first pretrial.
set it for another pretrial.
Your Honor, we had made a proposal to resolve the case, however, the state's not agreeable, so that's okay. So we need to proceed to obtain discovery in this case and probably have one more pretrial, if that's okay, with the expectation that it'll need to be set for trial. But I think another pretrial might be appropriate to make sure there are no discovery issues.
Prosecution agree?
Yes.
You have a date, you want to do it?
Can we do it on the 30th or the 14th either?
30th is fine. June 30th. Pre-trial, 10 o'clock.
Oh, shoot, Your Honor, I forgot. He asked me not to set anything for that date. He has a vacation pre-planned. When will he be back?
July 14th, is that the other date you wanted?
Yeah, that'd be fine, July 14th. Thank you.
Strike that. July 14th will be the next pre-trial.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Christopher R. Hale, case number CRB 2487.
Okay, this was set on the review docket, and Mr. Hale is here now. He said, so you got him in? Okay. It's a good report. Okay. And do you have a payment on your funds today?
No, but I get paid next week. I got some community service done. I paid 40 last time, but I'll if I can, I'll probably pay 25 because I went on vacation. I only got a week coming to me.
You still have 24 hours of community service schedule?
Yes, sir. I'll get that done. I'll be here on Saturday.
Okay, I'll cancel the warrant. Set your next hearing. July 11th.
Yes.
9 o'clock.
Yes, sir. Thank you, sir.
Continue with your treatment like you've been doing.
Yes, sir.
Thank you.
You're welcome.
State of Ohio will recall Christopher Faulkner to Lawrence County Jail, case number CRB 25335, CRA 25334.
All right, Christopher Faulkner is there. Yeah, I've got your urine screen, Mr. Faulkner, and you're positive for methamphetamine. I know you shouldn't be. I agree with you, you shouldn't be. It's bad stuff. Yeah. Turn you in from a 36-year-old man into a 56-year-old man in about 3 years. Sure. Okay, so what I'm going to do, you need to get some treatment. How do you pay for medical services?
I don't have a medical insurance on this.
Do you have a medical card?
No, sir.
Have you ever had one?
It's been years.
West Virginia?
Yes, sir.
Is that where you're from originally?
Yes, sir.
Your Honor, he has that extradition too.
Yeah. I'm gonna let, he said he could post bond on it. He posted on, and it's only like, it's basically I'm not sure it's a felony. But it could be, because it's over $1,000.
Yeah, I just
But
want
not much.
I just want to go see my daughter, sir. I'll do anything if I want to do any program, anything. I just want to go see my daughter all this time.
I'm gonna give you, and you told me you could post bond on this Kentucky thing, right?
Yeah, I should do that.
I've set your bond at $1,500 cash or surety, so $150, $200 gets you out on that. And then I'm going to order that you go turn yourself in Lawrence County, Kentucky, and you know which court to go to, right? Louisa, it looks like.
I guess it'd be Louisa, sir.
Lawrence County District Court. It was Louisa Police Department was the one that filed the charges.
Okay.
Yeah, shoplifting basically is what it is. So, go turn yourself in. I'm gonna set it. You got a bond up, so what I'm gonna do on the other charges, I'm gonna keep both your bonds in place. Once you go turn yourself in Kentucky, I'll discharge your bond on that, the 1,500. I'm gonna keep the others in place. I'm not gonna sentence you, and I'm gonna order that you get some treatment. Where do you live in Huntington?
I live outside of Huntington, so it's Buffalo Creek was.
Buffalo Creek Road.
Yeah.
Is that Wayne County?
Yeah, it's Wayne County.
Okay. Is that close to Howard Springs Road?
Yeah, it sounds familiar.
Okay. I'm trying to figure, because Huntington runs into Wayne County, but I'm trying to figure out where Buffalo Creek Road is.
It's in between Livelet and Canova.
Okay. Yeah. Can you, do you have transportation?
I could, yes, sir.
Okay, I'm going to order you to go to OVP for treatment. Ohio Valley Physicians. I actually think they have, it's probably closer for you to go to Huntington than Wayne, isn't it?
It could be. I mean, yeah.
Probably you're about halfway in between both.
Yeah.
Okay, their main office is on, you know where 20th Street is in Huntington?
Yeah.
It's where the stadium is. The football stadium's on 20th Street. So if you just go south on 20th Street to 8th Avenue, or 7th Avenue, it's on 7th Avenue. It's before you get to the viaduct. OVP, its main office is there, and you can walk in there and get treated. And I'm ordering you to do that.
Okay. How long do I have?
2 weeks. I'm going to order you to come back in 2 weeks. And I want to see a report from OVP. Usually they have somebody here, and they'll give me a report as to whether you've been there and what you're doing on your treatment. And then I'll sentence you then, or I may sentence you, I may keep the bond in place. Here's the thing, if you don't show up, you got a bond in place, do you know what the bail bondsman does? He'll come get you, yeah. It's not like you can just go hide out and don't have to worry about going to jail. He's going to come track you down, take you to the jailhouse. So go turn yourself in once you get your bond posted on the Kentucky matter, and I'll set it the same day. So that's going to be the 23rd of June.
Okay, so that's turn myself in as soon as possible, right?
Well, at least before June 23rd, because what's going to happen on that day, I want to have the prosecutor call Kentucky prosecutor and say, is the warrant lifted? If they say, yeah, it is, he showed up, then you're good on that. If not, then that's going to be a problem. And if you don't show up again, we'll tell the bail bondsman to go sick you.
Okay.
So you know what you need to do? Turn yourself in Kentucky and go to treatment
Okay.
at OVP.
Okay. So I can have, I need to get all the bondsmen in today to pay the 200 or whatever?
We'll let him know. You want us to let him know that you need to talk to him?
Yeah, please.
We'll do that. Okay, June 23rd, 2 weeks from today, you gotta be in court in Chesapeake. You know where the court is in Chesapeake?
No, sir.
Do you know where Chesapeake is?
I know where Chesapeake is.
Okay, you know where the downtown bridge is going over 6th Street to Huntington, right?
Yes, sir.
Okay, if you were coming from Huntington across that bridge, when you get to the first light, in Chesapeake, turn left. It's probably a mile and a half from there. That's County Road 1, it's on County Road 1. And our claim to fame is we're across the street from the flea market. So if you see the flea market, the court's right across the street. And you gotta be here on June 23rd. Okay, so you post your bond and you'll get out today. We'll let the bail bondsman know that you want to post that bond. I'll send him a text right now. Any questions about what you gotta do? Okay. So that'll actually be sentencing on his case here.
I appreciate it, sir.
Okay, good luck. Do what you're supposed to do, then you can once you get this all straightened out, be a father to that baby.
State of Ohio versus Carolyn Jacks at the Lawrence County Jail, case number CRA 25341.
Okay.
Hello.
Oh, there she is. Okay, she's still in the jail. You got any place for her to go?
Judge, I talked to Brianna, and she was going to have one of her team do an assessment. Carolyn, has anybody from OVP contacted you over the phone?
No, sir. Well, I was talking to the lady earlier, Miss Emily, and she said that there was a 1-800 number that she had given me, but I guess one of y'all or someone here is supposed to call them because I needed to get emergency Medicare, because you couldn't find my insurance under my name, my Social Security number. And I asked her if she could use my number, she said, but she couldn't get any information from that regarding me. So that's where I'm kind of in limbo there. I don't know exactly what to do from there. Because I got the 1-800 number she gave me.
Who gave you that?
Her name is Emily.
She must have been from OVP.
Yes, that's where it was. But I mean, if I can, but we're separated right about now, so I might, most likely I probably not on it, so.
Judge, would you like for me to make a quick call to Brianna and see what the results were?
Yeah, if you want to, try to can you get a hold of her? Okay. We're gonna we want you to stay right there. Is this the last case?
Yeah, it's there now, yes.
If you can just leave her in the chair, Mr. Morford's gonna make a phone call and we'll have her, hopefully we'll call her right back. Okay, on Joshua Murrell, we actually could not find the judgment entry on that, so I'll just mark it complete, let Judge Waldo do what he's going to do with it. We'll complete his file with her. I'll text John Kincaid and him that.
State of Ohio versus Kerry D. Tucker, case number CRB 25217, A and B. Your Honor, this is set for trial. Mr. Morford, I'm ready, Mr. Peel, forward.
And I think this is one he said he was going to dismiss.
I'm hard of hearing, so I apologize.
This is one you wanted to dismiss, right?
I wanted to state on the record the reasons for it.
Okay.
This case involved two ladies. It's your birthday today. Happy birthday.
Thank you.
Two ladies that I think if they got them both in here and they were honest, they'd say they wish it had never happened.
Exactly.
And I think they both might have been equally guilty of some things towards each other that was described as a road rage incident.
Yeah.
And really, from the fact that we don't have any witnesses except the two parties, and I can't prosecute both of them at the same time, my intention is to dismiss the charges against both this lady and also the other defendant.
Okay.
So,
I appreciate that.
All right, so you're okay with that now?
I'm great with that.
Go in peace. Your case is dismissed.
Thank you so much.
and Your Honor, I'll be presenting an entry to nollie that case against the other person too.
Okay.
Which will better. You're welcome. Happy birthday. Sure.
Mr. Morford in there, did you make contact?
He's talking to someone.
To OVP.
I don't know. It's gonna stick.
Whatever.
One thing about it is,
Yeah, let's do it by jail. That's a clean way to do it. Let's do it by jail. But you did get some jail time.
something has changed, and that sounds more like a disc than it's the nurses.
Find out anything?
Apparently, they have not done an assessment yet, Judge. I was not able to reach Brianne. I left a voicemail for her. So I called OVP and talked to case management, Kathy, and she was going to have somebody call down and do an assessment. But I can't tell you when that's going to be done.
Okay, so on Ms. Jax, what I'm going to do you think you could post any kind of bond, ma'am? Your audio's off, I'm not hearing you. Oh, yeah, you're muted, let me unmute you, or ask them.
Okay.
Can you think you can post any kind of bond, Ms. Jax?
The only one that I do have is through my husband, and he's on the boat, and there's no way that he can send me anything.
Okay, well, here's what I'm gonna do. I'm gonna set a bond for you of $1,500, that's minimal, cash or surety bond. Set your hearing, if you can post bond, you gotta be at the court on Friday, which is the 13th, June 13th. If you're still in jail, we'll deal with it then. If OVP says they want to take you into treatment, I can do an order releasing you before Friday to go to OVP. And I'll let Ms. DeMint know that if they're willing to take her, we can do that. Do you have a phone number where you can be released or be reached if you post bond?
Yes.
You want to give that to your lawyer? He's listening.
Okay, 304-774-67.
What were the last four?
6070.
6070, thank you. Oh, Judge, can I go into this? This is OVP.
Okay, yeah. Okay, they're calling right now.
Hello. Hey. Okay. I'll relay that to the judge. We actually have her up on the screen right now. Yes, the judge will allow her to come there for treatment. Okay, thank you, Brianna. They're going to accept her, Judge.
Okay, we just got word from OVP, they will accept you.
Okay,
to go inpatient
okay.
treatment. So hopefully they'll be picking you up today, and then let's just still keep her on the docket for Friday to make sure that did happen.
Okay,
So they'll bring you to court on Friday if you're there.
I'll be there.
Okay. Now, if you leave, you have a felony, so a warrant will be good wherever you go. You can't get away from it.
Oh, you don't have to worry about that, Brian. I'm here with Bill, Brian.
Okay, all right.
All right, thank you.
So I'll change it to an OR bond. I had said 1,500 OR bond.
You said what now, sir?
I'm changing your bond so you can get out. You don't have to post any money. I wasn't sure you were gonna be able to go into treatment. If you left, I wanted to make sure we had a way to get you back. But now you're going to treatment, so I'm just gonna let you sign a signature bond.
Okay, then, well, thank you so much, Your Honor.
You're welcome.
And you have a great day.
You too.
Thank you, Judge.
Court's adjourned.
Music to our ears.
I'm not supposed to come back to these kind of days. Days up to the police.